So now let's run into what is the other costs which are being specified by the board, and then I'll explain you what exact point am I trying to highlight here. So the IRP costs as per the regulations mean amounts due to suppliers of essential goods and services. So those who are supplying essential goods and services as regards this moratorium provision, they should be provided the top priority. Then fee payable to authorized representative under 16A8. Now this is also a insolvency resolution process cost, that is the AR fee. Now OP is incurred by the AR will also come into that. Then if there is any amount which is due to a person whose rights are prejudicially affected on account of moratorium, that is, let's say there is a landowner and you are not, I mean, you were asked to continue because as per the moratorium, they cannot ask you, they cannot terminate in terms of section 14. So therefore, you are continuing to stay at those premises. Now, see, because their rights are prejudicially affected, all that amounts which are due to them will by default become in CIRP costs. Then fee payable to the board, that is IBBI, there is a regulatory fee. This amounts to regulatory fee. Then expenses incurred on or by the IRP to the extent ratified under 33. Now, this is what would be a point of interest for our discussion. Now, as regards IRP, all these expenses to the extent ratified by the COC, then expenses incurred on or by the RP fixed under Regulation 34, and other costs directly related to the CIRP and approved by the committee. Okay, now let's try to understand what this ratification is by quickly running into Regulation 33. Now in 33 it says, all these expenses shall be ratified by the committee as insolvency resolution process costs. And in terms of resolution process costs, that is RP's costs also, it says that all these expenses are something which are being incurred by the RP. Now, when we talk about this particular definition, that is any cost incurred by the RP in running the business of the CD as a going concern. Now, the point which I'm trying to draw from the reading of these regulations is that, say I am incurring certain cost in terms of paying salaries to the employees and some ancillary expenses or miscellaneous expenses, including employee benefits or I mean, some kind of beverages which are being supplied to the employees during the day, and other basic expenses which are particularly to ensure that I am running the business of the CD as a going concern. Then all those expenses, does it require the approval of the committee, or because the regulations, that the definition says that this amounts costs incurred in running the business of the CD as a going concern, and in the regulation it does not talk about such costs. So does that mean that there is no need of approval of the committee, is what is one question which I want to deliberate. Now over here, what we need to understand is that this last point under the regulation says that other costs directly related to the CIRP and approved by the committee. Now, other costs directly related to the CIRP, does that other cost include the definition provided under section 5 of the IBC is what is a major challenge. So here is a question which is not just about the law, but also the intent. Now, if my interpretation goes to a way that all expenses incurred by the RP for the purpose of running the company as a CD do not require any approval of the committee, then it may amount me so much power as an RP that I can incur any expense on this planet and ensure that I'm not going to the COC at all, because the existing operations are able to deal with such kind of a cost. Now, is that what is the intention? I don't think so. I feel, in my opinion, once ratified by the COC, that kind of a cost will also become a CIRP cost. Now, there is one provision which kind of provides for that kind of an understanding. If you see Regulation 31B, Regulation 31B talks about approval of committee for insolvency resolution process costs. In this regulation, it states that the IP shall place in each meeting of the committee. Now, this is an amendment which has come in February 2024. And what it does is that it says that in every meeting, the IRP or the RP, as the case may be, they'll have to place the operational status of the CD. Okay, then what is the operational status? What is the status of the current operations of the CD has to be provided to the CD, to the COC, and shall seek its approval for all costs which are part of the insolvency resolution process costs. Now, this kind of sets the tone because it says seeks its approval for all costs which are part of insolvency resolution process cost. So, irrespective of whether the cost is forming part of the insolvency resolution process cost or not, the moment, irrespective of whether the regulation or the law is talking about ratification or no ratification, etc., with this amendment, it has become kind of clear that all costs which are part of insolvency resolution process cost shall be put forward before the committee for its approval and along with the operational status of the company. Now, this amendment, why should it be coming as an amendment? Does that mean before this, the RPs were not doing it? No, RPs were definitely doing it on a month-to-month basis, and wherein, as and when there is a meeting, the RPs were duly informing the committee members in terms of all the costs they have incurred and also the operational status of the company. However, now it has been made completely mandatory. Now, over here, let's try to understand that this is a situation where there is a going concern, right? But if we just have to deviate from the topic to understand in a situation where there is no going concern, then obviously the entire operational status of the company will be nil. There would not be nothing much to discuss, but it'll become nil. So yeah, this is about the approval for insolvency resolution process cost, which also includes these costs for running the CD as a going concern. So how do we ensure that we have committee's approval for all these expenses? Again, I have a question there. Now let's say there is a company which has a CEO, and of course they are also director, and their powers are being suspended after this. And as an RP, the RP is stepping into shoes and ensuring that the entire operations are being run as a going concern. Now, during the process, the RP starts incurring huge expenses towards, you know, towards ensuring that the resources, because many of the human resources have left the organization to optimally utilize the existing ones. He started incentivizing them, or she started incentivizing them with, you know, uh, increased salaries or whatever. No, because there is increased salaries, then the IRP has to go to the COC every single time to get this particular cost approved. So, but is that even possible? The answer is no. So, what can be an ideal practice in terms of this particular cost? And when I say cost, it is approving the cost incurred with the RP in running the business of the CD as a going concern, right? So now, if this is what is the cost, that is, what is the, if this is what is the issue in terms of cost for running the business, then what the IRP does or the RP does is at the beginning of the meeting, the IRP or the RP, or maybe at the beginning of the COC itself, that is maybe in the first meeting or the second meeting, the IRP or RP, as the case may be, will propose the entire budget. The entire budget for a estimated period of 6 months will be presented, and this budget will also include the salary cost. Now, how is the salary be budgeted? It will be budgeted based on the business of the company, based on the past business and past months or past few months of businesses, and also based on the existing man force and the required man force for the purpose of running the show. So this way, the IRP or the RP will prepare an entire budget and place the budget before the committee for its approval. And subsequently, does it do away with ratification? The answer is no. Or approval? No. Definitely, the RP will again put forward the other cost for approval or for noting. Now, how does it happen? Like it depends. There are multiple practices which various RPs are adopting. So I will try to explain one by one. The first practice is that as and when an interim result, as and when an budget is being proposed for approval, and let's say subsequently the RP is incurring expenses within the budget. Now, where the RP is incurring expenses within the budget, the RP, there are multiple practices. One of the practices will be for the RP to inform the committee that this expense has been incurred within the budget approved by the committee. Now, this is also a valid practice, but it's just that the particular part, the actual details of those expenses were not with the COC at the time of they approving the budget. However, there was a justification provided for that particular figure, and if any expenses are incurred within that, ideally there should not be an objection. But there are again there is a backdown. Drawback in that particular process. The drawback being that whenever we have such kind of a practice, there is always a concern that the actual expenses incurred might not be in a position to serve the purpose or was not even required at the first place. Because when they are approving the budget, it is at a broad level, so the COC may consider approving it. But when they actually look at the relevant expense, there may be certain additional views which the COC wants to offer, but it is already late. So taking a complete approval for the budget and then subsequently, taking note of the expenses incurred is also a valid practice, but it depends on the comfort of the committee. But the most adopted practice would be that even though it is still um, even though it is still approved as a budget, subsequently the RP or IRP specifically places it again for the approval of the committee, stating that number one, it is within the budget approved. Number two, this is put forward for approval in terms of the expense already being incurred. So this is one kind of a practice where the RPs try to tell the COC that on both the levels, and they have received approval from the budget. I have given all the payments and I have incurred the expenses within the budget. However, I am also putting forward or placing forward these particular details to you so that you will take a wise call. Right? Now, particularly coming on the going concern thing, the expenses such as salaries, and there may be expenses on purchase of equipment, purchase of raw material. So there are various aspects which happen in a going concern case, and it would be really impractical as regards this regulation of the IBBI, wherein it says that every 30 days you need to have a minimum meeting for every 30 days is what the current regulation says. And of course, such period may be increased by the COC. But as per the IBBI, in every meeting, we have to place the approval for all the costs which are being incurred. So, which ideally means, let's say today we had a COC meeting and we have circulated the minutes on Monday, and we needed another meeting because of an urgency on Thursday. Now, this urgent meeting called by us on Thursday, even for that meeting, we will have to place before that committee whatever are the costs which are being approved in the interim. So the idea is good. The idea is that all the costs which are being incurred has to be regularly updated and filed with the IBBA and regularly updated and provided to the committee rather COC. So therefore, that's the objective with which such kind of an approvals are being sought. And however, or also the regulation is being framed. However, practically certain professionals are experiencing difficulty particularly in big mandates where there are huge operations. It is highly difficult for the accounts team of that company to even boil down to give the figure of expenses unless they have a high technology which they can rely on, which automatically generates all the expenses, because there will be numerous number of expenses being incurred and it has to be boiled down to only those expenses which pertain to CIRP cost. So, ultimately incurring the cost and making payment of the cost in a going concern is also a huge challenge. Okay, that's what's one thing I wanted to highlight. And next comes the challenge on interim finance. So for interim finance, I would like to draw your attention to how the interim finance provisions are being framed, wherein it doesn't talk about, the raising of interim finance is purely by way of a particular, definition. So it simply says that interim finance can be like the amount of any interim finance is included under the definition of IRP cost, CIRP cost. So having read that, we will get an impression that, oh, that's great that, we can raise funds and then it already has priority. So there should not be a reason why the lenders also should say no. That would be a general perception. Like, for example, what is this CRP cost or interim finance being a CRP cost? What level of protection does it provide to the COC? The level of protection it provides to the COC is that if at all there is a default in servicing this interim finance, they will have the highest chunk. They will have the super priority even over all the secured creditors. Now, that's the protection which is being offered by this regulation, right? By this code. So thereby, what is it doing? Even without a security interest being created in favor of the bank will still have a super priority, super priority even over the all the existing secured creditors. So ideally speaking, the risk cover is 100%. The repayment has to be 100%. Like, for example, let's say the value of a company is only 2 crores. Let's say the recovery is only 2 crores in liquidation. And the interim finance incurred, let's say, is again 1 crore 80 lakhs. So the entire 1 crore 80 lakhs go to the interim finance. And only the balance 20 may be available for distribution. So this way, interim finance has been granted its highest priority to ensure that there is good reception in the market in providing interim finance to revive certain units. Now, next is on the practical aspect of that. As regards the practical aspect of this particular point, that is raising of interim finance, this takes me back in time when I was working in a CARP of a steel of a tire manufacturing entity. So wherein we were supposed to we wherein myself and my boss, we were calculating on a monthly basis as to what is our current production and what is the order book we have, what are the repeated orders we generally have, what kind of trend we have, and accordingly we projected for certain months what level of expenses will incur, including RP fees, advisory fees, or on a periodical basis, what other expenses we will have to incur. Everything has been carefully documented. And when we did that, we started playing with the numbers to see to it that if we have to increase this number, or the top line, if that is the revenue, if we have to increase or whatever, if we have to do all of that, we needed certain fund. So what we did was we did a detailed math to identify what level of expense, what level of fund do we need to ensure that all these expenses are being met. So when we did that exercise, we got to know that, okay, we will need so and so fund on a monthly basis to meet the working capital. The major reason for that fund, to avail that fund, is because of the high working capital cycle between supplier and the CD. Like, wherever the company is purchasing raw material, it is purchasing it by giving 15 days of credit, while the same raw material, after being processed and sold as a finished goods, they are able to recover we are able to recover it only after 30 days. So on a whole, what actually transpired is that this particular company was unable to meet its working capital requirements because its recovery, its debtor cycle, the cycle of recovery, payment to the all the suppliers is very less, right? While its credit cycle provided to its customers is pretty high. Now, being that of a situation, that is only possible for cash-rich companies. But for company undergoing CIRP, every month, every month there would be certain expense which has to be incurred by the company. So therefore, it becomes of paramount importance for the IRP or RP to ensure that adequate funding is in place to see to it that the company is continuing to function. So having did that, we did a detailed exercise and went to the COC. And in the COC meeting, we have very clearly explained, like, this is what is our existing P&L, like the existing earnings. Then there is no interest payable to all the banks because it is under moratorium. Therefore, we only need certain interim finance from any of you so that this interim finance can help this company to slowly and gradually start reviving by the time the RA is in, the resolution applicant takes over the company. So with this objective, we have presented a detailed presentation on the interim finance. But unfortunately, though we have spent good amount of manpowers in finalizing the document, to our utter surprise and also for as an unfortunate disappointment, the COC took hardly 1 minute to dismiss all of this requirement. So as regards the point of view of the COC, they I mean, usually their thought process would usually be that we don't want to put in even a single money because we have already exhausted all our resources in getting this company into, I mean, in providing funds to this company. The director would have been absconding, or maybe the director is not responding properly, etc., etc. So therefore, based on whatever be the scenario, the COC ideally does not encourage raising of interim finance for running the operations. Having said that, there are certain finance institutions which do provide for such kind of an interim finance, and they also come forward and explain the COC, what is the product, what is the interest rate, etc. And there are cases where COC has approved it. But in generally, the tendency of the COC is not to incur any additional cost. And as far as the existing operations meet the requirements of the organization, the COC will not have any, COC usually does not have any, I mean, will try to listen out to that particular argument and try not to continue the same. So, it's as regards the COC, interim finance is a cost. And for running the operations of the CD, finance is something which is usually required, particularly because, the funding which we would require for ensuring that the company is running as a going concern is being provided topmost security. So, particularly because of that particular reason, this concept of interim finance becomes much more important and possible. So nowadays the practice is that one of the bankers of the CD are providing that kind of a service if we do not have certain pulses or edges at the unit. So I mean, if we do not have certain idea with respect to how these businesses can be run at the unit. Now, having discussed on the interim finance, let us also try to understand the position of bank guarantees. Now, for a running business, there may be a need for bank guarantees to be renewed, particularly when the business is dealing with contracts with the government. So, where the business is dealing with contracts with the government, it may be so necessary that the company, that's the corporate debtor, has to avail certain corporate guarantees. So we will have to discuss on how this corporate guarantees will be dealt with in the CIRP. So we'll just take a quick 5-minute break and then continue this topic on availing bank guarantees by a corporate debtor during a going concern sale under CIRP. I'll be quickly back in 5 minutes. Thank you. Yeah, thank you. We'll now continue the session from yeah, just a moment. Yeah. Now, in terms of managing the company as a going concern, there is one more area. I mean, or I would say not. I mean, one more aspect as to litigation. So when I say litigation, it is that we may face a situation where the RP is finding it difficult because of one particular, let's take an example, let's say because of one particular landowner. Like we have our raw material in a particular warehouse. Assume it's a warehouse and where we kept certain material, and we need to lift the material while the landowner is restricting the IRP or RP from lifting such material on the ground that the past dues with respect to that particular facility or the warehouse have not been paid. Now, it is a matter of law that all the past dues have to be, all the past dues has to be, uh, a claim has to be filed for all the past dues. However, practically, we see a lot of challenge and arm twisting by these landowners to say that, okay, you guys vacate the property, we will not renew this lease unless you make us the payment of the past dues. Now, with this kind of attitude and with this kind of reading of the law by the general by these kind of landowners, it becomes paramount important. It becomes of paramount importance for the IRP or RP to approach the NCLT to fight to pass necessary orders. So that's where we have a role of NCLT in terms of managing the CD as a going concern, wherein on various occasions NCLTs have passed, given immediate reliefs under Section 60, subsection 5, any miscellaneous applications filed for providing support to the IRP or RP, and even for ensuring going concern status of the CD. There have been multiple occasions where NCLTs have issued directions to various parties using their inherent powers. Now, there are a few such instances we can discuss. Like, for example, again, as I said, this land, in one of the cases in NCLT Hyderabad, where there was one of the landowners who was not, allowing the company from shifting its raw material because of by demanding old dues, the NCLT immediately appointed an advocate commissioner and directed that this advocate commissioner will ensure that all this material is being taken over by the company and within a particular specific period of time, and certain fixed fee has been fixed for the fee has been fixed to be payable to the advocate commissioner. So this is one in such instance in NCLT Hyderabad where the NCLT has proactively allowed such kind of a step. Similarly, it may so happen that during this process, that is during the CIRP, uh, I mean, one of the you had to take a bank guarantee from a particular bank, and the bank is demanding for a particular security interest to be created. Now, in order for you to create a security interest during CIRP, of course, it is possible by way of filing the charge form. But let's say for some practical reason, the charge form is unable to be, is not in a position to be filed. So even in such cases, applications have been moved before NCLTs to allow them to file for it so that so necessary funding will be received and they can continue to run the company as a going concern. So there are various occasions when NCLT has raised up to the occasion to ensure that RP has necessary support to run the CD as a going concern. One such regulation as well as the NCLT's discretion is with respect to giving directions to a district administration. So at times it may so happen that let's say you are going into a factory, and all the existing labor workmen amounting let's say thousands of such workmen do not let you enter the premises. They stop you at the entrance of the premises, maybe at the instructions of the suspended directors, or for maybe their salaries are not being paid for so long, so they want to strike. So whatever be the reason, they are not letting you in. Now at this juncture, as an RP, since you have to take control of the situation and go inside, you have no other option but to approach the police. let's say the police being unaware of this IBC or for whatever be the reasons they are not supporting you in this, then if you have every right to approach the NCLT so that the NCLT can offer a solution, so the NCLT can provide a solution with respect to giving directions to local district administration so that the local district administration shall cooperate and shall come forward and support the IRP in terms of support the IRP to come with the IRP alongside the IRP and to give the protection to the IRP in taking control of the particular situation, in taking control and custody of the assets of the corporate debtor. So this way, the company will have, this way the IRP can take support of the local district administration using the powers of the Honorable NCLT. Now, now the other aspect which we have to discuss is with respect to, one specific aspect in a going concern which I wanted to deliberate is regards the concept of occupier. Now, the concept of occupier is not a new concept which we are discussing only under IBC. It's a concept which has evolved over a period of time under the Factories Act, wherein one of the directors of the companies shall be an occupier, right? Now, assume all directors have resigned, right? If all directors have resigned, then what happens is the IRP or RP will will de facto become the occupiers, because other than the directors, all the powers of the directors, if they are vested with somebody, it is only with the IRP. So IRP becoming a occupier is a question which we need to understand. Now, further, let us take an illustration. The illustration is that there is an ongoing CIRP, right? And in the ongoing CIRP, there is an accident. Now, when in an ongoing CIRP, there is an accident in the factory, who will be responsible? Right? Now, this is something which we need to understand. Now, let us try to spend some time on questioning as to first understanding the particular situation. So, the particular situation is that there is a ongoing CIRP. So, when I say ongoing CIRP, it means that the IRP as well as the COC are actively ensuring that the company is going as a going concern, is being run as a going concern. So now in this situation, for some reason, whatever happened, there was a fire accident and couple of workmen have suffered huge injuries, and another 3 to 4 workmen have minor injuries, and majority of others were able to escape the injury, but there was a huge threat at the factory because of this accident. Now, police obviously will start their investigation, but the first question would be that who is the occupier of this factory? Now, why are we going there? Because as per the Factories Act, anything which happens in the factory due to the negligence of the management, maybe any fire accident, anything, there has to be one person who has to be responsible for that. The person may not have the intent to do it. The person may not be directly or indirectly involved in that particular accident, but that person will be deemed to have the responsibility to tackle that particular situation. And therefore, a director is somebody who is mandated to be becoming a occupier of the company. So the Factories Act very clearly says in case of a company, any one of the directors of the company as appointed by way of a board resolution or authorized by way of a board resolution shall only be eligible to be appointed or nominated as an occupier of the particular factory. Now, as I was giving you an illustration, let's say all the directors have resigned. So when all the existing directors have resigned, particularly in Maharashtra, I've seen that the Department of Labor has been pretty pretty proactive to state that because all the directors have resigned. Oh, sorry, this was in state of Gujarat. Because all the directors have resigned, they very clearly said that this factory license will be renewed only subject to condition that the IRP is being nominated as the occupier of the company. So it has so happened that the occupier renewal has also come. Sorry, the factory's license renewal has also come. So at the time of renewal of the factory license, they very clearly said unless the RP, sorry, unless the RP is being confirmed as an occupier, this license will not be renewed. Now, what is the effect of license not being renewed? The moment your factory license is not renewed, you are not authorized to run a factory there. You're not authorized to do any operations there. So therefore, the entire operations will be at stake. So hence, in that case, the RP took a stand that okay, he will become an occupier, and he accordingly allowed, you know, uh, himself to be nominated as occupier. And even there was multiple orders wherein it very clearly captured that nominating IRP or RP as an occupier is nothing wrong, or is something which is as per the law. There are certain orders which justified that. So now in a going concern situation, when we are managing the CD as a going concern, also being responsible as an occupier, this is an additional responsibility in addition to the IBC. Now, IBC, of course, gives you a condition that all the existing laws has to be complied. So, compliance of laws is also one of the responsibilities of the IRP or RP. That apart, this liability is in addition to what is under IBC. So, merely conducting the process and ensuring that the 180 days are run in a way which is envisaged under IBC will not save the RP from their responsibility, in particular in a situation where there are no directors on board of the corporate debtor. So in such a situation, this occupier, so in our now coming back to our illustration, there is an ongoing CARP, there is an accident in the factory. Who will be responsible? It will be the RP who will be responsible, ideally under the IBC as well. But the challenge of being an occupier is, firstly, he will be responsible. Secondly, when if since this has to be an affair has to be filed to investigate such kind of a mishap, the first accused would be that of the occupier, who will have to justify beyond reasonable ground that he or she is not responsible for that particular accident and it has happened without their involvement. So this positioning as an occupier will have its own repercussions. The repercussions being that, like when we when the IRP or the RP is taking such additional responsibility as an occupier, this would amount to the IRP or RP dedicating extreme caution at the factory and ensuring that all safety measures are adequately implemented, and if required, certain cost has to be put in for maintenance of machineries and other safety aspects if the operations have to run smoothly. So the moment because usually in other cases, whose names are nominated as occupier, those who have like plant heads, those who have proper functional idea of how the units are being held. So they are the ones who run the process. While we I mean, while this while this aspect of occupier has not been too popular, particularly because there are not many companies which are undergoing CAR, which are having operations. But again, whenever you come across a case which is undergoing CIRP and having operations, and you are appointed as an IRP or RP, this particular position of who is an occupier will also be extremely important. So if you are willing to continue an existing director as an occupier, it is preferable to put it before the COC and take an approval that existing director is being continued as an occupier, and see to it that you are continuing that existing director to act as the occupier. The reason being that those directors whose names are usually occupied as occupiers are the ones who have technical knowledge over the plant, the ones who have relevant experiences, or the ones who, who were having adequate field experience in terms of handling such kind of units, etc. So they will be the best to handle these kind of ongoing cases with ongoing businesses. So this is one good aspect I thought we need to understand in terms of a going concern sale. That is the concept of an occupier,
Sir,
particularly
I
an
have a
IR.
question, please.
Yeah. Go ahead, sir.
If permitted. Say, for example, when I take as IRP or as an RP,
Uh-huh.
and there is a remaining director on the board.
Yes,
Later on, he hands over his resignation to me.
correct.
So, as an RP or IRP, do I have the authority to reject that rejection or not to accept that resignation?
Okay, sir.
Oh,
Sir,
yeah,
yeah, in my opinion, sir, a resignation by any professional or any director or any employee is a personal right. And the law of India does not allow any such restriction of bonded labor. So, any director or any employee of the company who wants to resign are well within their rights to resign. And we, as an RP or COC, will not have the relevant authority to not accept such resignation. Only area would be a procedural implementation. May there might be a difference, sir, but effectively, a person who wants to be resign, it is their personal right to resign. So we
yeah.
as an RP cannot stop. Yeah.
Say, for example, if article provides that the resignation must be uh, approved in the board, and there is no board to approve that resignation.
Correct, sir. Sir, in my opinion, article providing such fact is also not correct. It may also be ultra virus. Why? I'll tell you.
Okay.
The Companies Act has introduced, when it comes to resignation, under 168 of Companies Act deals with it, if I'm not wrong. So
Yeah.
what it says is a director who is resigning will be resigning upon the receipt of this communication by the company or a later date, whichever is later. And a director will have a right to file a DIR 11 on their own with the
Yeah.
ROC, intimating resignation. So the law is also very clear when it comes to resignation that you cannot stop a director from resigning for whatever be the condition. But the director will be responsible till the time he is on board. But
Okay.
if
Yeah.
the director wants to resign, it is something which is a personal right of the director, which cannot be restrained by anybody. And in my opinion, is even as an officer of the court, neither the RP or even possessing the powers of the COC under Section 28, COC has one power of change of management. So even using that power, even the COC cannot curtail this, sir. But sir, having said that, in Reliance Communication, when
Yeah.
Anil Ambani has submitted his resignation, the
Yeah.
COC rejected it.
Okay. Yeah.
But later it was not contested. So, I mean, COC rejected the resignation. They never accepted the resignation, and therefore he continued as a director. He never contested that kind of a rejection from the COC. But in
Yes.
my opinion, I feel that was only because of the the kind of reputation they have. So they didn't want to spoil it or whatever. But
Yeah.
ultimately, I feel nobody can stop that. And I think you would also experience in all our cases, majorly independent directors tend to immediately resign. They don't want to
Yes.
take chances of continuing in insolvent companies. And they don't even wait for our acceptance. It is only a one-way communication. So I feel, sir, there is no embargo on resignation of a director is what my opinion is.
Okay. Very clear. Very clear.
Yes, thank you. Yes, sir. Just to quickly conclude on this aspect of occupier, so where we are managing the company as a going concern, and if the company has manufacturing facility, this concept of occupier becomes pretty relevant. Now, in addition to this concept of occupier in a particular factory, we need to also appreciate one fact that there may be situation where a company, I mean, it might be too hypothetical, but it is still possible. It may be so possible that the company has multiple factories, one in the state of Maharashtra, let's say the other is in the state of Andhra Pradesh, let's say one is in the state of Telangana, or that way it may be in various states. Now, will the RP be occupier of all these units? The answer may possibly be yes, if there are no directors on the board. But if there are directors on the board, then the RP may nominate as director as occupier, or the existing directors who are already nominated may continue as occupiers of the respective units. But what if all the directors resign and the RP wants to nominate somebody? The RP has to get somebody first in the position as a director, appoint them as directors, and then nominate them as occupiers of that particular units. So because see, if you see that as an RP, we cannot be omnipresent, right? We can be managing the show from a particular place. We may frequently keep visiting these units, but trying to get into the daily operations of all these units will become quite hectic for an RP. And that's why we have plant heads who are also occupiers who will take care of the operations of the particular unit. So therefore, occupier is not for the company, but for the factory. So wherever you have a factory, for each factory being registered with the respective department, you need to have a occupier. So that's how the concept of occupier becomes complex when there are more operations and more units of the respective entity. Now, this is something which again needs attention by the IRP or RP, and it even a tough calls like stopping the operations may also be taken if adequate safety measures are not being adopted at the respective units, or if it is impossible for the RP to adopt such kind of measures considering the cost involved, then RP or the IRP may take a call that even these operations may stall till safety measures are being implemented, or they may inform the COC that it will be huge, risky on the lives of the workmen, and therefore also will affect the RP. I'll give you one example, a very unfortunate incident though, but an interesting case study is that the entire CIRP, the RP was there. The company was functioning there. The company had a manufacturing unit in Nagpur, in Vadva near Nagpur, and it was running quite good. They were able to make good positive EBITDA during the process and all. And the new management has taken over, and they were also doing good. Within a period of 6 months, the management decided that we need to do maintenance of but of the boiler and other major equipment and machinery. So they literally had to stop the production for that particular period in time to get this maintenance done, because all these machines were old, and during the process there was no funding, so they were not maintaining this machinery. So they took that step, and quite unfortunately, during such maintenance, an accident occurred, and two workmen have suffered severe injuries. Now, based on the severity of injuries, also there will be a lot of issues. So, severe injuries have been have happened. And by that time, the resolution applicant had already taken over the company. So, what happened? Can the resolution applicant blame the RP? No. So, the resolution applicant, what they did to avoid any criminal cases, etc., they offered monetary compensation of 50 lakh each to each of the employee whose life was at threat, and they offered 100% hospital expenses till recovery, till their permanent recovery. They offered that they will take care of all their medical expenses. So with this assurance and agreement, there was no criminal case initiated against them by the workmen, and accordingly, they didn't have a. They were able to escape it. But ideally, usually, what happens in case of occupier cases, if that kind of a settlement is not happening, and if suppose the workmen feel it is pure, it's a negligence on the company. If they file a criminal complaint, firstly it will be filed against the occupier, and it will go into litigation for ages. So it would be irrespective of whether that occupier left the organization or not. Remember this, an occupier is personally liable, not just by virtue of his authority as a director, that only vicarious liability. No, the occupier will be personally liable in addition to the company. So irrespective of whether the director had left the company or not, whether the occupier had left the company or not, the occupier will continue to face this litigation till the entire criminal case is being dispersed. So is being dismissed or disposed. So that is one major challenge of becoming an occupier. Now, in this case study which I've just given, where the RA resolution applicant has stepped in and provided a settlement of 50 lakh each, and given assurance to give that health reimbursements, etc. Just imagine, had that incident occurred during the CIRP, what would have happened to the stake of the RP? Now, do you think the COC will immediately disburse 1 crore rupees or 50 lakhs each to be paid to each of the individual workmen? The answer is an obvious no. The COC will not be willing to do such kind of a payment, and they will not take such kind of a responsibility. So as a business, the business people have a lot of calculations, and they do understand the sensitivities involved, and they swiftly do these kind of transactions or take these kind of decisions. But when it comes to a committee, there are different minds, different ways of looking at it, and ultimately the responsibility is on the RP, who might have been nominated as an occupier because there are no other directors in the company. So things would have been extremely sad and difficult had that occasion been, I mean, had that unfortunate event happened during the time when the IRP is in force, or IRP or RP is functioning. So I feel, as an RP or IRP, I mean, at least the one good thing is that now under each of these Factories Acts and other departments, there is a recognition of the role of the IRP or RP. That's a good sign. That's a green flag. But one aspect where I feel there can be an improvement is this, but I mean, particularly under the Factories Act, there can be certain tweaks made, or maybe one set of rules prepared, particularly when a company is undergoing CARP, some relaxations has to be provided as regards the role of the IRP or the RP, so that there can be, I mean, the IRP or RP can peacefully function and ensure adequate measures are in place during the process. Because the moment the IRP or RP steps in, expecting the IRP or RP to take complete burden of the company might be extremely challenging expectation, and therefore that kind of a relaxation might have to be supported in a situation like this. So that is with respect to occupier. Now, as regards the other aspects, that is in terms of processing the salaries, is one other aspect area where I would like to spend some time discussing in a going concern situation. Now, when I say processing salaries, now generally payroll processing is something which is done by the HR, right? Now, payroll processing is one aspects, one aspect, but there are multiple aspects in terms of understanding who would be responsible for ensuring the authenticity of that particular information, right? That is, let's say, I mean, let us assume that in a given month, the HR of the company approaches the IRP saying that, sir, as on today, we have 920 employees. The total cost is around 1.5 crore. Therefore, you will have to sign for it. This is the salary sheet. Now, you as an RP, what would you do? How do we process how do we authorize salary payments, right? How do we authorize salary payments is a question of regard. And also, another interesting area I'd like to discuss when it comes to going concern. Just a second, I'll share my screen. Yeah. Another interesting question is on increments. So let's say I mean, again, I understand majority of us would have experienced cases not having any funds, but there are also cases in India in under IBC where there have been certain funds with the company, but the debt was pretty high that they were unable to service the debt. However, the funds being generated are good enough to meet the salaries and other expenses during the relevant month. So with that assumption, I was trying to make all these situations and hypothetical issues. Now, first and the foremost is payroll processing. Now, I'll just give an illustration how in one of the cases where we are handling the payroll processing has been handled by the HR during CARP. So what they do is they have an app which records the entry and exit particularly the attendance of the employee. Now, how is this attendance being monitored of the employee? Is that he is by way of a biometric. So there's a biometric machine by which it captures at the time you come in and the time you go out. And there is a particular shift. The shift is of 9 hours each. And if you are working for more than and for an excess of excess of 4 hours, it is considered as one day of overtime, for which the salary payable for one day is being paid to them. So again, that overtime has to be approved by a particular person from the HR or from the relevant department of the particular person. And after this attendance is being tracked, that Excel, which is populated from the tool, which records the attendance, will then be provided to the HR. Now the HR has individual CTC. So what the HR does is applying the formula, they will manually using the Excel compute. Of course, manually I mean using the Excel, but it's not an auto-generated tool. So they will then monitor what level of expenses, sorry, the HR will then monitor what salary has to be paid to each of the employee. Then that list will then be forwarded to the relevant departments to confirm on the maintenance, to confirm on the overtime payment to be paid, and finally the list is shared with the RP. Now there are two things. Number one, the RP may have an opinion that okay, these guys are intentionally putting some random names, while those names should be somebody related to the directors or somebody, so the salaries are being taken back by few of the directors by way of the funds are being misutilized or diverted by these directors by providing certain names which I am not aware of. Such kind of suspicion may be there on the there with the IRP or RP. The second possibility is the IRP or RP may basically blindly trust whatever is the process provided, and they were signing it, considering the total quantum. Both of these things are there. But in my opinion, the ideal scenario should be, again, as I said, an SOP. So there has to be a standard operating procedure on how right from attendance till a payroll processing, what are the various steps which has to be mandatorily complied, and under each step, how do they ensure that the IRP, as an IRP or an RP, what level of role they will play in terms of approving at each of these stages. So, right when the attendance is circulated and also when the HR is preparing, at least one personnel from the RP should be there at the site, or should be there with the HR who are computing this kind of a system of salaries. Second is that when the best part can be that if there are some funds which can help the IRP in ensuring adequate compliance with respect to payroll processing, then the IRP should ideally, the IRP or RP, what they should ideally do is they should ideally rely on a software than on a human resource. That is, than on particularly the HR department. So, because all these people who continue to work are from the were usually reporting to the erstwhile management, so it may or may not be trustworthy for the RP to rely on such kind of working. So, if at all the existing tool or the improvised version of the tool can address the payroll processing issue, so during the process as a CIRP, it is extremely helpful for the it will be extremely helpful for the IRP or RP if the payroll processing is being automated, and that would save a lot of time, and even the reliability factor would be completely gone. So that way the payroll processing will become one major challenge, and will have the IRP or the RP should carefully plan the payroll processing to the employees of the company. And then authorizing salary payments. So again, authorizing each of the payment to each of the employee may again become a huge challenge. So therefore, at least a level of sampling has to be done. And those appointment letters of those selected employees should also be cross-verified. so that we can be assured that adequate fight you put on. I mean, so we can ensure even the CARP process, the COC, that adequate measures are in place by which we are able to identify that there are no cases of non-existent employees, or that all these salaries are actually being created with respect to employees. So this way, authorizing salary payments will also be a key thing. And finally, increments. Now, why did I want to talk about increments? So it may be a natural practice or an assumption. We may feel that during the CIRP, there should not be any scope for increments. Now, as a only for because we are on an academic forum to discuss this academically, in my opinion, there's nothing which stops the RP or IRP from considering providing some percentage of increments. It can be less, high, low, whatever. But practically, is it how it is done? That I am not sure, but I don't think um, an existing director, I'm sorry, I don't think an existing RP resolution professional, the resolution professional can uh, can propose for increments or increment policy of employees during a year. So usually the IRP or RP do not want to get into such kind of legal tangles. So therefore they continue at the same increment, and their intention will be to hand over the company to a third party, and the third party will then decide whether to change the name in the third party will decide whether such kind of an increment, or the RA will decide particularly whether such increment should be given or not, and all that. So the RP will usually try not to take such kind of a stand, particularly when these kind of increments kind of a situation is aroused. Right, so these are various issues which we face in a going concern when managing the CD as a going concern. But apart from this, whenever a CD is being managed as a going concern, there is always there is always a possibility that the COC would be interested to know the cash position of the company. So knowing the cash position of the company is another important aspect in a CIRP situation. Sorry, in a going concern situation. Now, what is the meaning of cash flow position of the company? So by cash flow position of the company, it is intended that whether these funds will be so excess that can it be distributed to the COC or not, will usually be the mindset of the COC. So COC will be interested to know, fine, you're making money during the process, well agreed, but when is the recovery and what is the current cash flow position or cash position of the company? So when I say cash, I also mean obviously cash at bank and cash at bank, particularly the revenue. Okay. So, the credit which has happened to the company, because it may so happen that, or particularly in a going concern situation, cash generated during CIRP. Okay. So cash generated during CIRP will usually become the asset of the company. I mean, cash generated during CIRP will usually become the asset of this company, and the COC will usually have a clause to address this. Okay. So COC usually prefers to have this cash distributed to COC. So that's usually the you know that's usually the expectation from the committee of creditors. So cash generated during CIRP, how do we, what is meant by this cash generated, and what all things might come under this particular ambit? So there are two issues which may come under this ambit. One, the actual monetary amount which has been generated during the CIRP, which is lying in the bank account of the company after meeting all the expenses. Second is with respect to the receivables built by the company. because you may have to give that window, you may have to give that, um, the minimum period of credit for your customer. So there would be receivables on the books of the company even during CIRP. So these receivables also would be kind of a cash generated during the CIRP, and usually the COC members would prefer to have that distributed to them in the same manner of distribution offered in the resolution plan. Now, what is the reason that COC is interested for this to be done? So, COC's interest is that because during this process, still a resolution applicant is being, provided or maybe asked to provide with a resolution plan. Whatever efforts are put by the RP should essentially be passed on to the COC and not to the new resolution applicant, is what is the usual tendency. Now, are there cases where there were a good amount of operations, etc.? Yes, there are good number of manufacturing entities where the operations still continued, and there was obviously in few cases of CARP, though the operations continued for a particular period. Subsequently, the operations never sailed through. The RP or IRP had to give up, particularly because there was no working capital kind of, there's no working capital per se in the unit, so therefore they had to discontinue the operations, and all the employees would return, and the employees would gradually become zero. So these situations are also quite common, and similarly there are situations where there was successful revival even during CARP. For example, SR Steel. In the case of SR Steel, in the case of SR Steel, there was indeed there was indeed a situation where during the process the EBITDA had turned positive. So that is one area where where the ambit of going concern is I know that's one case where we have seen that even the recoveries were pretty high, and you know uh, the uh, the existing operations were also not depleted, and the value has been there was a value addition even during the CIRP. Now, before we conclude our session, I would like to touch upon one last issue in terms of going concern, in terms of managing the CD as a going concern from the point of view of the real estate sector. Now, in real estate sector, the very issue comes from understanding what is a going concern for a real estate sector. Okay. So in a real estate sector, what would be the meaning of a going concern is something which we need to be extremely aware of to then proceed to see what are the various situations where this going concern might be a challenge in a real estate sector, and the legality of the same in a real estate sector. So let me just allow me to share my screen. Yeah. So the going concern aspect in the real estate sector, in my opinion, would be to sell the properties. So as long as I'm as a developer in a position to sell all the properties in accordance with the or sell not all the properties, but in a position to sell the properties of a real estate company, then I think like in a real estate company, particularly which are with operations, I've seen very few occasions where the RPs have done the registrations and taken the considerations. Usual scenarios would be where 100% considerations have already come, but right at the stage when a negotiation is being there, I mean, right at the stage where, right at the stage where in the real estate sector, um, where all the installments have been paid and only the registration is pending, even those aspects are being done by the RP by getting the registration done. But actual going concern aspect in a real estate sector would not just provide for selling of properties, but it would also encourage manufacturing of the same, right? So, right? So in a real estate sector, where the inventory is nothing but the real estate properties like house property, villas, or whatever, where such kind of villas are being um, I mean, are not being like, let's say there's a real estate company which has, let's say, 13 villas, and of which 50% consideration has been received from all the 13 home buyers. Now the balance, or let's say 18, okay, all the or 13 was fine. The all 13 home buyers and 13 flats, 13 villas. Now, for all these villas, these 13 home buyers would have filed their claim, right? So now it comes to a situation where can the IRP demand for the balance consideration from the respective landowners? Now, demanding this from a respective landowner and grandma is different. So, I mean, particularly when you are selling real estate, I mean, selling flats or other house properties in real estate versus infra projects which are being implemented, etc. Now, since if at all the company has funds, then yes, the law allows the RP in getting this registration done and also to park the funds for completion of construction. But having said that, in a going concern situation, it would by default be extremely difficult to take care of a real estate company even without a going concern status. But if there is a going concern status, then the actual potential of the real estate sector would be known. And the basic idea of having restrictions on real, on the basic idea of placing restrictions on such kind of a sales and keeping it within the COC to ensure that nothing of that happens is to see to it that there is certain discipline in terms of a going concern, managing a going concern even in the real estate sector. Now, when we talk about managing a going concern sector wise, so there's just one point I would like to highlight here, that based on the sector, based on the business, based on the stakeholders of a particular company, the strategies to be adopted for managing the CD as a going concern will have to be altered. And secondly, and most importantly, not just handling the managing the CD as a going concern, but alongside it, the RP should also conduct the insolvency resolution process. And when the IRP is conducting such insolvency resolution process, all these employees who are working in that respective unit must be curious in terms of knowing who would that other person be, and um, and also whenever there is whenever the RP is managing the CD as a going concern, the RP will have an inherent responsibility to see to it that there is no decline in the operation. So the RP will always have a fear that due to the age of the due to the age factor, I mean, sorry, the RP would see that in a particularly in a going concern situation, the RP would see that because there is a transition period during the time when the orders are being passed by the NCLT and when the RP is stepping into as an IRP or RP, the IRP or RP will have a primary responsibility to study the sector for which they are being appointed as the consultants. So now, sorry, appointed as the IRP or RP. Now, when this IRP or RP are managing the show as a going concern, depending upon the sector for which they are being appointed, they can jot down what are all the issues which can come up. And accordingly, each of the issues has to be dealt with in accordance with the law, has to be appraised with the committee, and only then decisions have to be taken. So ideally, when there is a going concern, the chances of the chances of stakeholders misusing it would be really high. Like, for example, they know that the company has some funds lying in a respective account. So one of the banks may simply adjust that amount with the personal account of with the loan account maintained with the company. And at times it so happens that there would be a TRA account. Right, the TRA account is a transaction specific account where once the amount hits the TRA, that particular amount, some portion of it, 80 to 90% will be taken away by a bank, because we are talking about insolvent companies. Now, when these companies have stepped into CIRP, will such conditions still apply, or will there be a difference in respect, is what I was observing. And definitely there is a way, the moment there is a well prepared, when the RP is well prepared on the relevant sector, and all the relevant provisions or relevant analysis made of a particular sector where the going concern where the going concern status of the CD is being maintained, that will help the IRP in better preparation right from the date of giving content till the order is passed, so that immediate steps can be taken. Now, just before I conclude, one case where I am currently functioning as an IRP, currently is still in the first 30 days phase, is a company based out of Tindivanam near Tamil Nadu. It's a very small unit, extremely small, next to the highway, and they manufacture aluminium boats. Now, when I say boats, it is the boat which goes into the sea, rivers, water, and all that. So they manufacture aluminium boats. So now the next question, what I tried to do within this first 30 period yesterday's, and here in this case, they are partially, working, and for some, for some part, like, the plant per se is not generating funds now. And as I understand, there is not much competition also in the industry. Neither there is too much of demand in this product. So, as an RP, I had to bring in my business acumen, whatever be the limited knowledge I have, to see whether this company currently is a going concern and what kind of revenues the company is generating. Then I realized, okay, there is hardly any revenue they are generating. Then the next question would be, right from the first meeting, to see who can be the competent people who may show interest in acquiring this business. Now, if you see this particular business for which a company for which I'm appointed as an RP, they have certain intellectual property, like designs of the boat, and not just the designs, but also certain minute aspects as to how the boat has to be, the safety measures of the boat and etc. are also well designed, and or there are approvals in place from the relevant government department in the name of the CD for functioning, for immediate manufacture. Whenever they want to go for manufacture on the board, their designs are already approved. So these situations will help us in understanding whether any efforts have to be put by the RP in reviving the business during the process, or should the RP continue the process as it is, or the operations as it is, so that any new RA who is coming in will then start the process afresh. So these are certain questions which will haunt us whenever we are doing a process in a CIRP. I tried to focus my discussion on various challenges which we are facing and what is the role. So the idea was to give a brief idea, brief analysis of how a going concern, managing a company as a going concern during CIRP can be challenging. And yeah, it may definitely be more remunerative than in any other ordinary CIRP mandate, but it comes with its own set of challenges, particularly one area which, of course, is not part of my presentation though, but particularly when the COC decides to liquidate the company, and in the liquidation, when the COC is exploring the idea of selling it as a going concern. Now, this is one thing which always makes me think that when the NCLTs are, or even the IBBA are so skeptical that they want the CARB process to end in 180, 270 or 330 days, and they are not encouraging giving any further extensions these days. But they don't mind the same aspect of going, exploring as a liquidation, exploring as a going concern to continue during liquidation. And generally, the outcome of liquidation should be that the company has to be, the asset has to be sold to someone, or the company has to be dissolved. But in case of a liquidation as a going concern, there are multiple cases where at times the company shares, has been acquired by a particular entity, or demerger has taken place and all whatnot. So, the very difficulty of liquidating a company as a going concern is highly difficult, because the moment there is a liquidation, the entire employees are deemed to have been discharged, of course, not excepting for going concern sale. But at the same time, the morale of the employees will go for a toss when they hear the word liquidation. So when they realize that, okay, this is going to be the end of the company. So various sensitive issues, various sensitive aspects will come in the foreplay whenever we do, deal with companies having operations. But the one good part is, monetarily, all the expenses will be met in time without any delay. And also, there would definitely be huge level of satisfaction for the RP in continuing the functions of a running unit, which can gain more value addition to the COC by way of cash generated during the process. And apart from it, there would also be a huge advantage to the COC in better marketing this asset and gaining better market presence in terms of and also it becomes quite interesting and quite easier for the IRP or RP to market the asset to reach a huge number of resolution applicants who can show interest in the company. So with this, I conclude the session in terms of our the going concern aspect. So I'd leave the floor open for any questions or for any open discussions. If there are no such questions or queries to be discussed, we can conclude the session. So I'd request ICSI IPA to take over and inform if there are any questions. I would be more than happy to discuss. Otherwise, we can conclude the session. We did discuss a couple of issues during the session. So thanks for that participation from the IPs. But if there are anything else or any personal experiences the IPs would like to share for the larger audiences, that would also be extremely helpful. So Anjali, over to you.
Participants, if there are any questions, kindly discuss with Prakul sir. Otherwise, we have to conclude the session. Are there any questions?
I have a question regarding the eviction part, which you were saying that when
Yes,
when the suspended directors are not evicting or any tenant is not evicting the property of the CD, just can you again repeat this?
I'll repeat that. I actually, what happened in that case was, we were occupying a premise, and the landowner was not allowing us to take our assets from that premise. And in fact, what happened was, the rentals were not paid for 2-3 years, and the landowners were not allowing the raw material in the lease in that particular property to be taken over. There is no official arrangement of lien or any seizure of the property, etc. So as and when IBC has come in, the landowner said, no, I'm not going to let you take this property out unless you are making me payment of the old dues. So the RP explained that, boss, you will have to file your claim for the old dues, and you cannot retain this property because these are assets belonging to the CD and I need to take control. Sorry? Yeah. And subsequent to that, the landowner again tried to twist the arms of the RP by saying that you pay me all the lease rentals right from that particular date or CIRP date till this date, and only then I'm going to release. So our argument was that we never had a lease arrangement with you. You have wrongfully kept the properties at your site and you are supposed to release it. He never budged. So we went to the NCLT, explained the same situation. The NCLT very clearly said that the stand of the landowner is not tenable. They cannot retain the properties. They have the properties, I mean, the assets. The assets belong to the CD and they have to be rightfully released to the CD. And they have appointed an advocate commissioner to take over the assets. So this is what had happened. But also on the flip side, what you have asked, in one of my cases in a real estate case where I was handling, there are certain flats which are available for sale, but one of with whatever be the arrangement with the suspended directors, one tenant was one home buyer who has booked a flat in one of the under construction projects was temporarily allowed to stay in a already constructed block in a constructed flat. But on record, he never has an agreement for sale for that flat. His agreement for sale was in another project, in the same project, but in another block which is still under construction. So he filed his claim for that under construction block while he is continuing to stay in another unit or another flat, which is ideally available for sale and mortgaged with a secured creditor, and without any permission from the secured creditor, is continuing to stay there because the suspended director asked him to do. Now, here we can't find fault with this tenant also, because he has done it because of the suspended director. But at the same time, as an IRP, because I have to take it as a going concern and I'll have to consider the current position of law. The current position of law is that it's a secured asset and the asset belongs to the company. Now, because somebody else is illegally staying there, I had to send a legal notice to evict that person that person from the premises. Now, this is one situation where, as an RP, as a CD, we have sent a notice for eviction of property by one of the tenants. But otherwise, I was discussing the other way around, where when we are running the operations, there can be situations where we have certain leasehold properties, certain premises which we would have taken on lease, but we may not want to continue such premises. But our assets may still be lying there, which the landowners may try not to release, only to ensure that their lease rentals are paid. So though they understand the position of law, they don't want to adhere to it, because obviously anybody would love to want the money back. So that's what I was discussing, ma'am.
Yeah, okay, thank you. And regarding eviction,
Yeah.
can we apply to the NCLT for eviction, and how much time normally it takes for normally?
Yeah, ma'am.
It's not
Ma'am,
always the same in every case, but usually
ma'am.
how much time it takes?
Ma'am, ideally, eviction, in my personal opinion, we need to follow the respect to state tenancy laws for the purpose of eviction. Because ideally, NCLT has jurisdiction, a very limited jurisdiction. But having said that, in NCLT Chennai, I did, when I was doing my internship with NCLT Chennai judicial member, so I did observe certain orders being passed passed in favor of the RPs for eviction of a particular unit which was under the possession of the directors illegally, or maybe somebody have wrongfully taken a position. Like, in fact, even in NCLT Bengaluru, where currently I am having the case, same project which I was talking about, one tenant had wrongfully taken the position. That was purely through anti-social elements. They have come, they barged in, they changed the locks, and they took the position and control over the flats. So we filed a police complaint, and we also went to the NCLT. And immediately after the listing, we filed for an interim injunction, wherein we said firstly, that fellow has to hand over control back to the RP, and status quo has to be maintained till this IA is disposed. And immediately that IA was allowed on the day one itself in NCLT Bangalore. And similarly, in NCLT Hyderabad, we see a very quick way of disposing these kind of reliefs, wherein there is a good scope in terms of where it's an illegal occupation. Immediately there are orders being passed in every NCLT, hardly in the same hearing. But for listing of it, maybe 1 month, and then for the final disposal, ma'am, probably 1 to 3 months goes away in the final disposal, in ascertaining what rights the other party has, and purely depending upon the actual facts and the merit of our case. So where we can very clearly prove that they are using their physical power, and they're trying to barge in without going to the court. They're coming with antisocial elements and illegally occupying or taking possession of a property and trespassing the property. There, the chances of getting orders within a month are high.
So it was like a police complaint and interim injunction, and thereafter you went to NCLT.
Interim injunction also I got from NCLT only. So right on the day one, I filed 2 IAs. One IA is for interim injunction, and the other IA is for the main relief. So in the same IA where I filed for main relief, within that IA, I filed another IA for interim injunction. That IA got listed, and that immediately they have given me the interim relief has been given, asking the existing guy who has illegally occupied to go away from the property, to evict the property immediately and hand over control back to the RP and maintain status quo. That was my immediate prayer, and that got given. Had that been my main prayer, the NCLT wouldn't have passed that relief till the entire merits are being heard and orders are being passed. Because it was my interim prayer, wherein no party is being prejudiced, because it's a CIRP, and this fellow never took possession before the CIRP. Even suppose assuming he had rights, he never took it before CIRP. But after me coming into control, using antisocial elements, barging into the property and taking over the control was not necessitated. Had he had a right, there is a proper way of doing all this. So since he didn't do it, the NCLT was within its powers to immediately grant such kind of an order asking him to evict. So we got that favorable order. It was very recent, actually, in June first week or something. We got this order.
Okay. And there is some provision that we can complain to the IBBI, and IBBI deals up with the eviction part. Have you dealt with that part?
No, ma'am, I didn't. But from what I understand, what IBBA does is usually under the IBC, particularly where there are criminal offenses, that's where we apply to IBBA, and IBBA files it with the sessions court. That part I was aware. But this eviction part, this is news to me also, ma'am. I'll also have to see. I have never come across that situation. A
Yeah, I've
complaint.
also heard in a webinar, but
Okay,
I've
okay.
still not been able to take up this thing.
But what I know of is that where under the code after section 67, there are certain penal provisions. And because NCLT does not have jurisdiction to pass orders of criminal in nature, so that jurisdiction is vested with a special court. But as an RP, we cannot initiate any such case under special court. That can be initiated only either by the Ministry of Corporate Affairs or by the IBBI. So we have to formally pass this information to the IBBI with a request to initiate criminal action. Then IBBI, at its own independent decision and judgment, they will decide whether or not to initiate such criminal action against the promoter or a resolution applicant who has not implemented a plan. So these aspects, or anything where there's a contravention of moratorium or a fraudulent initiation of CIRP. So all these areas will come there where there is a penalty prescribed. So maybe that we'll have to check, ma'am. If at all there is a penalty prescribed even for this kind of illegal occupation or trespassing, then even for that we can apply for IBBI. But otherwise, I don't think specifically there is anything for IBBI to act upon in a relevant situation for eviction of a particular property.
Okay. And regarding thefts, like
Yeah.
how to deal with the theft part during the proceedings, be it liquidation or CIRP?
Yes, ma'am. Ma'am, ideally, as I was explaining, even during the process, be it a going concern or not a going concern, theft is something which might occur. So, I like even before CIRP you take, there may be situations of theft, and after CIRP or as well. What is important for us as an RPs is to ensure, did we have adequate measures? Like, for example, first, did we have a security who is sitting there or not? Now,
Yeah.
suppose it's a theft, and let's say it's a dacoity, like somebody has actually started threatening or maybe using violence against them. So that's something which we can't avoid. And suppose it's a theft, and it also happened when we still had security, and suppose still we had theft, then
Yeah.
what we need to do is to immediately ensure, as immediately as possible, we are filing a complaint with the police and identifying what is the nature of theft, what asset has been, what was the asset which was subjected to theft. Now, this beyond this, as an RP, I don't think we should also be personally made liable to the value of the asset or something, because it's in a natural process that there are such kind of offenses being committed. What we need to establish is we have kept adequate measures in place. Now, there can be situation also that, ma'am, we have proposed appointment of a security agency, considering that there is a chance of theft, and let's say COC never approved the cost for appointing a security agency. Now, in such a situation, again, there is a possibility of theft. And when we go complain to and again, of course, but still our responsibility to go and complain to police will still be in place. But what we need to see to it that at least in our minutes, we're adequately recording our efforts to ensure that efforts highlighting that there is a huge concern of theft of property because there is no security. So we should not, because there is no prior record of theft, we should not assume that there may not be any theft. So it's always ideal that once we enter as IRPs or RPs, we need to ensure, if at all there are movable properties in our site. It's an immovable property, then the only thing we need to be worried of is any trespassing. But if there are any movable properties in our site, we should ensure that there is a security engaged, considering the value of the property. If there is machinery, or if there is some kind of vehicles lying there, we should ensure there is some security, considering the value versus cost, we always have to consider. But having a security is something enough. Other than that, we will not be in a position to stop something from happening. But our immediate actions also are noted by IBBA. That suppose we see a theft, then immediately are we recording it? Are we immediately reporting it with the police or not? Are we filing the complaint? How quickly are we filing the complaint? These aspects also matter a lot, ma'am.
Gotcha. Okay.
Yeah.
No, we have filed a complaint. I faced this issue. I have filed a
Ah.
complaint. It was for the security agency was also there, and in fact, the security guards were also involved.
Okay.
Checking. We
Uh-huh.
removed those guards,
Ah.
but there was no recovery. We could trace out like where they have sold the scraps, and they have taken away the money already.
Okay.
We could
Okay.
not recover the money, and these people were bailed out. They bail and they were outed. So that was the outcome of the FIR. And we could not reach with them. In spite of knowing who are the persons involved, the police could not reach them.
Oh my God. Mm.
Like there is no other
Nothing we could do about it, ma'am, because it's purely out of criminal. This NCLT will not have much to do there. Neither does IBBA. It's just out of our common law, whichever is available to any business will be available to us in this situation. So it's like just the systemic failure. That's all.
Okay. Thank you so much. Thank you for answering
Thank
all.
you.
Yes,
Thank you, ma'am. Thank you.
One more query, if it can be answered.
Ma'am, go ahead, ma'am. I'll try if I can definitely.
This is with respect to EPF. EPFO, I'm facing this issue that I need to upload the ECR list of the employees. Now, I don't know to what extent I'll get the support from the suspended directors. And suppose if I don't get, because whatever money we pay to the EPFO, unless and until the ECR is submitted, that amount will not be credited to the account of the employees.
Correct.
And it lies standing with them. So in that situation,
So they are not providing the credentials or the details, ma'am, the directors?
He is always saying that I don't have any person with me now. I have left all persons, so it is difficult for me to send.
Okay. I think in such situations, one thing which can help us is to directly go meet the relevant EPFO officer who deals with our account. Because it's usually they only voluntarily come and register accounts. I mean, the usual practice is that our HR approaches the EPF authority, ESS authority and all, we get the relevant registrations done, and subsequently other compliances are being met. But wherever we face challenge, these EPFO officers always have a hand in terms of ensuring that relevant compliances are being handled by the new entity. Like whenever there is a takeover or whenever there is a change in management, like for example, a new company, in case of mergers particularly, when we take over this entity, the new management usually approaches the EPFO to change all these details to a new entity. So using that logic, I feel I didn't experience this, of course, in many cases, because in two of the cases which I did, we did get all the information flow and support from the management. But in the event that doesn't come, I feel going directly and meeting the EPFO authority one-on-one and submitting all this communication information to them that, see, we are ready to pay, we are ready to do this, but because of this lack of information and lack of communication from the director, we are not in a position to implement this, is something which we have to do by going and meeting them in person. And they do allow us to meet in person. They give us their appointments and we can do that now. And if there is a possibility of ma'am, if I understand the query right, so this is a
Yeah, yeah.
challan, right?
Yeah.
If the challan generated only when the challan is generated and we deposit, that's when relevant professionals, employees will get that PF reflected in their respective EPF accounts.
Yeah.
So they will definitely help us out on this, ma'am. If we can meet them in person,
Okay.
they will definitely help. But we need to know who is the relevant EPF authority.
Okay.
That also usually directors will have to give. If they don't give also, jurisdictional EPFO we can find from the websites.
And that is easy.
Correct. So if we approach them, they are approachable. That's what I'm trying to explain. They definitely, if when we are with an intention to implement, they will give the solution how to do it.
Okay. And my last query is regarding GST registration. In case
Yeah, ma'am.
we require GST registration as a liquidator or as an IRP or RP, and when we don't get the support from the directors and the previous GST has already become inactive, and we need to go for a new registration, like how to get, because we don't have the director details, especially with respect to the PAN and Aadhaar card and the photograph.
That's true, ma'am.
Is there another way of getting the registration?
I think that's one loop, because even in my cases, the same thing happened. But then they don't listen. The GST authorities do want those details. So I currently don't know how is that possible. But what I can sense is that if we give a valid explanation to the GST authority, by way of, again, we need to physically meet them, but we need to give them a valid explanation why it is not possible, that and we can do it using our PAN and Aadhaar. Because there is a circular in GST allowing IRP to register a PAN.
Yes. But for when you go for a company registration, the director details is a must. Though the authorized signatory can be the liquidator or the RP,
Yeah,
but
correct.
they
Director
require
details,
the
signatures
director
also
details.
does.
There is a thing where we get stuck because we don't have the PAN, Aadhaar, or any documents of the directors. In fact, they don't share with us. Though we have the numbers, PAN numbers and all, but for the attachment, that is a difficulty.
That is a difficulty. Agreed. This I am not particularly sure of how it transfers, ma'am. I'll have to check that and get back to you, because I didn't experience this part, because luckily I got that signed in one of the cases in Karnataka. I got it, but what difficulty I faced was getting it signed from the registered owner. Well, our registered office is again in the uh, one of the landowner had to sign on that property because he is the owner of that particular premises where we have treated it as registered office. Now for that office only I'm applying for a GST. So there we had certain difficulty in getting that approval, but again we were able to get it and submit. So we didn't face the concern. Only concern we faced from GST was there was a delayed application by us beyond that 60 days period or 90 days period. We filed it pretty late and we gave them an explanation and they've allowed it. So I feel, ma'am, maybe you can try this. I don't know if it works, but what you can try is you go ahead and apply. By instead of attaching an Aadhaar, you can attach explanation giving that this is the Aadhaar number and this is a company undergoing CIRP and the directors are not cooperating. And accordingly, we are unable to provide you the attachment. However, since as a RP, I'm providing all my personal details, etc., etc. So you're requested to kindly approve the same. Maybe try that out, ma'am. If it works, I feel if it added to this, if there is a query again coming from them, they usually send it to the legal and try to get the query sorted. So maybe this can help is what I'm thinking. Just try it out, ma'am. I don't know. Maybe just sort of, I thought it might help.
Yeah. Thank you so much. Thank you.
Thank you. Thank you. Yeah.
Sir, going concern means whether we need to comply Companies Act or not. So
Absolutely.
the issue we got with the directors. Recently, one case director has resigned and filed the Form 11.
Okay.
Now, there were only 2 directors were there. Only 1 director is there right now.
Okay.
Whether board is there. See, the power of the board is suspended, but not the board per se.
You're absolutely right, sir. The duties still continue. Correct.
Now, what is the responsibility of the IP or IRP to ensure the board composition as per section 149?
Sir, in my humble opinion, all legislations which apply to the company will apply even during CIRP, and we as RPs will have responsibility even to ensure the board composition. Now you're talking about a unlisted company. Suppose it's a listed company. Or in a
Correct.
listed company also, there is a requirement of board composition having minimum number of independent directors and other directors. So
Correct.
my advice in this situation is firstly to appraise this to the COC and see if they can allocate any budget. If at all they can, let's say they're allocating a very minimal budget of 5,000 rupees per month to a director or whatever. I mean, I'm just hypothetically giving an example. Let's say they don't want to give more than that, or some of sitting fees of 5,000 rupees or not exceeding that or something. Then as directors, we should take one step of circulating that within our circles and or in a newspaper, a very small advertisement inviting anybody to show interest to join us as a directors. Why I'm trying to do this is, if suppose, because today nobody is questioning it, but I see that ROCs were issuing notices to the RPs for not filing financial statements for past few years.
That's what one case we got notice, sir.
Exactly, sir. So to guard ourselves, we should at least, this can build our case to say that, boss, we were ready to appoint. COC has approved this budget, but nobody was showing any interest to join us as directors. That is one. Second, when it comes to other compliances under Companies Act, wherever possible, we should file it using GNL2. Even
of course, that form you can file without additional fees and
everything, even including this non-composition of directorship, let us intimate the ROC. We don't have the minimum composition. We went to the COC. COC never approved, and therefore we are unable to meet the minimum composition, and hence we are filing this. But however, all other compliances wherever possible, as an RP, I'm complying it. So till now, till 2022, this CEOs, Companies Act compliances were not taken seriously by any authority because they were firstly trying to struggle how to fit in IBC and Companies Act. Now, slowly and steadily, they are ensuring that RPs should be made responsible to file these financials. Now they have given us rights to file DIR 12. Upon plan approval, we as an RPs, we can file DIR 12 for appointment of directors. So that authority we got. Slowly for charge satisfaction also they are proposing. In fact, that is also there, but practically we are unable to implement it.
No, that is a form was not having the liquidator field or the CEO field.
Correct, sir. And then slowly they may in fact come and impose us on AOC 4s and others also. But as on today, through GNL2, we are being allowed to do. So point being made that Companies Act also, like we should also conduct AGMs, we should conduct board meetings. I know it's practically possible, but the expectation is, yes, the compliance said we are supposed to do it is what is the expectation.
Yeah, the reason is that while proposing any resolution plan,
sir,
and if the compliance is not there, even under the Companies Act, they're discounting it. Even they are saying that this is the price I need to incur for
to get correct to perfect the compliances. Absolutely, sir. And at that juncture, COCs are firing the IPs. Why didn't you do karke? Till then, they don't mind. They never appreciate paying for any of the compliance cost. But when the RA backfires, then they start coming and heavily at the RPs asking, why were you not doing all these compliances? So you're absolutely right on that, sir. It's actually
that's the problem. See, when due diligence will be including Companies Act as well.
Correct.
Why will they leave Companies Act? See, what is suspended is only power of the board. The board intact should be there. Board should continue.
Correct.
And then question comes appointment again. See, all people signed that DIR at 12, DIR 11, and we cannot prevent them from resignation also.
Absolutely,
Because there
sir.
is no bar from them to resign.
Absolutely, I'm on you on this. I'm with you on this. Absolutely, we can't
So they
restrict
can
them from
resign.
them.
They can resign
Yes,
and they can go and they can file it. The
correct.
person, whoever may not, no one will be interested to join in our board, especially.
True. Very true. So there is definitely leniency, sir, in terms of regulator in understanding RP's stand. Only thing is we need to show some efforts to tell them. If that also, I'm very far-fetched, I was thinking. Till now, that kind of a situation didn't arise for any RP with respect to minute non-compliances under Companies Act. Even ROC was quite relaxing on
Lenient.
that. Lenient. So because minimum number of board meetings or minimum notice of nothing of that sort they're coming up. Only major issue they are concerned is cost auditor appointments or basically auditor appointments, including cost auditor, sectoral auditor, stat auditor, and this financials. These are the areas where they're slowly coming up. Because recently in one of my client matters, I have seen that ROC has sent a notice for non-appointment of a cost auditor for a period during CIRP.
Okay.
So even when they know that is in the CIRP, but as far as they are concerned, they want to understand why. So if we can give them an explanation, if they are convinced, we don't know. It has come very recently, but still, I see that they are coming up with this kind of notes. Identify just like any other client case of us in a CS situation. Like as I'm also a company secretary, so I understand that in our client cases, we see that these are the compliances to be met. We should do a similar checklist for our own cases as IPs. And
in fact, I gave one section, what is that? MGT 8 for one company which is under CIRP. My entire MGT 8 was there in italic. Then you can imagine when next time when ROC looks into that particular form, then now what would be the non-compliance?
Yeah. No, you're right, sir. Because we also can't take risk of saying it's all complaint or whatever. It's not right. Because obviously there will be a lot of disclaimers and a lot of things which we need to do. Yeah. Yes, sir.
Nice lecture, sir. No, very nice.
Thank you, sir. Yeah, Anjali ji?
Yes, sir.
Yeah, I think we can wrap up the session, ma'am.
Okay, let me ask participants any more questions? Either we can conclude.
Yeah.
Thank you very much, sir, for such a nice presentation and sharing your experience and knowledge with the speakers. The session was very insightful. Thank you very much. Sir, further, can I request you to share the presentation
I will do it, ma'am.
so that I can share with the participants?
Sure, ma'am. Thank you. Thanks for the opportunity, ma'am. As usual. Thank you.
Thank you, boss. Thank you.
Thanks, everyone.
Now there is lunch break till 2:30 p.m. Next session will start at 2:30.
2:30.
Barsha ma'am will take the session.
Yeah. Okay. Thank you.
Thank you, ma'am.
Ma'am, shall we start now? Barsha ma'am?
Just a second. Yes, we can start.
Okay, ma'am. Good afternoon, everyone. Now the session will be taken by Barsha ma'am as faculty on the topic managing corporate debtor as going concern during liquidation. Let me briefly introduce Barsha ma'am. Ma'am is commerce graduate and qualified TCS, having more than 7 years of experience. She is presently working as partner in Vinod Kothari and Company, and she is engaged in corporate and resolution division of firm. She has been rendering end-to-end services with respect to insolvency and resolution services, corporate restructuring services, and litigation services, and she regularly appears before NCLT. She has been engaged extensively in resolution liquidation matters as well as advisory under IDC and corporate restructuring matters. Now over to you, ma'am. Please start the session.
Thank you, Anjali ma'am, and good afternoon, everyone. Thank you so much, ICSI, for giving me this opportunity to deliberate on this topic today, as to how to manage the corporate debtor as a going concern during liquidation. The topic is very important as of now, the law does not prescribe any particular mode of managing the corporate debtor as going concern during liquidation. While there is a provision, the section says that there are modes in which the corporate debtor can be liquidated, or the modes through which a liquidation of a corporate debtor can be concluded. One of those modes is going concern of corporate debtor or going concern of a business of a corporate debtor. So today we'll discuss about how to manage the corporate debtor as going concern during liquidation process. So let us start. I hope my screen is visible to all.
Yes, ma'am.
Thank you. I'll request all the participants to keep their queries in chat box, and we'll take the queries in between the session or at the end of the session. So today we are going to discuss regarding the meaning of meaning of going concern, ingredients of going concern, why going concern is preferable, effectuating going concern sale, and the concerns relating to managing corporate debt as a going concern during liquidation process. So first of all, before discussing regarding the going concern, let us first understand as to what this liquidation is all about, because going concern is shown as one of the mode through which a liquidator can be liquidated, a corporate debtor can be liquidated. So let us first understand as to what is liquidation. So there are 5 circumstances in which a corporate debtor can be liquidated. Circumstances can be such, say suppose COC has not approved, committee of creditors has not approved a resolution plan, or say suppose no resolution plan has been received during CIRP process, or resolution plan is received but not approved by the COC, or resolution plan is not approved by the adjudicating authority, or say suppose the resolution plan is received by the corporate debtor, approved by the COC and adjudicating authority, but ultimately is not being abided by properly, or the resolution applicant has contravened the provisions of resolution plan. So in either of these circumstances, the corporate debtor leads to or goes to liquidation. So liquidation is the last resort in which the corporate debtor is the insolvency of the corporate debtor leads to post this CIRP process. So CIRP is a chance in which the corporate debtor can be revived, or revival chance is given to the corporate debtor, and ultimately if there is no possibility of revival, then the corporate debtor goes to liquidation. But in liquidation as well, the chance of revival has been given to corporate debtor, which is going concern. There's one more chance, one other chance as well, which has been given by way of a scheme of arrangement. However, that chance is very or less explored. So coming back to this liquidation process, so we'll just quickly discuss about the liquidation process summary as to how this process is conducted. So the moment the resolution plan is either not received, or the corporate debtor or the COC is not approved, or not approved by the adjudicating authority, or the other reasons as I have mentioned just now, in that case, the adjudicating authority passes passes the order for commencement of liquidation. As soon as the order for commencement of liquidation is passed, then the liquidator is appointed by the adjudicating authority, and that liquidator is required to is required to make public announcement for invitation of claim. That claim from all the stakeholders who have dues as on the liquidation commencement date is required to be submitted within a period of 30 days to the liquidator, based on which the liquidator prepares a list of creditors to whom ultimately the distribution will be made. And based on that, a consultation committee, a stakeholder consultation committee is formed. After that, the liquidator prepares determines the liquidation state, which comprises of the assets of the corporate debtor as to what all assets are there that actually is required to be realized. And after that, the prelim report is prepared, wherein the details of assets which are there, the position of the corporate debtor is provided. Then the liquidator explore the modes in which the corporate debtor can be liquidated, invites expression of interest from the respective applicants with respect to the selling of the corporate debtor during liquidation process. Now, there are several modes provided here. The modes includes selling the corporate debt, assets of the corporate debtor on piecemeal basis, or by slump sale, or sell by way of parcels, or selling the corporate debtor as a going concern, or selling the business of a corporate debtor as going concern. What is the difference between the two? We'll discuss in a later part. And ultimately, once the process is complete, once the liquidator successfully sell the corporate debtor, after that the liquidator is required to either file the dissolution application or the confirmation application with the adjudicating authority, and is required to distribute the realized proceeds among the stakeholder in terms of section 53. So this is the whole process that is followed by the liquidator during the liquidation process. Now, coming to the modes, as I discussed that during the liquidation process, there are several modes provided in which a liquidator can realize the assets of the corporate debt. What are those modes? The modes are either slump sale, either piecemeal basis, or parcel sales, or selling the corporate debt as going concern, or selling the business of the corporate debt as going concern. So here, this going concern concept is particularly about these two factors. First is business of the corporate debt as going concern, or selling the corporate debtor itself as a going concern. So this going concern concept, if we see that the mode of, if we see the so far as to how many corporate debtor has opted for this going concern measures till now. So as of now, total 2,386 cases of going concern has been initiated. However, not yet concluded yet. There are 509 total cases which are closed by dissolution, and only 47 cases which are closed by way of going concern sale. Some compromise or arrangement matters are also going on, not concluded yet. So ongoing process as of now is 1516. Now, when we say that sell by way of going concern, selling either a business of a corporate debtor as going concern, or selling the corporate debtor itself as a going concern. So here the question comes as to what this going concern means, because it is presumed that the corporate debtor till it is surviving before CIRP is going concern. Once it is in CIRP, still there is a possibility of revival of the corporate debt. Hence, that stage can also be said to be as a going concern. But once the corporate debt moves to liquidation, it is gone concern. It cannot be considered as a going concern. So why at all this concept of going concern comes here? Because if we see the definition of going concern in accounting standard or in GST parlance, the definition is completely different. In accounting standard, it says that the actual concern is the expectation to remain alive, where we know that once the company is into liquidation, this expectation itself dissolves. So, and in GST, the expectation is the concern of going concern. The concept of going concern is seen from the view of supply of services, that there will be a continuous supply of services. In generally, if we see, the meaning of going concern is transfer of the undertaking. But when it comes to going concern in liquidation process, here it means it is one of the modes in which the assets of corporate debtor can be realized. So it is liquidation. In liquidation, this going concern is not a mode of continuing the business of the corporate debtor. It is one of the modes in which the business of the or the assets of the corporate debtor can be realized. So the ultimate concern of going concern when it comes to liquidation process is that there are assets in the corporate debtor. I'll request Anjali ma'am to please mute the participants.
Clear cut tell you come and collect it.
Anjali ma'am, I'll request you to please mute the participants. Right. So let us start. Let us continue again regarding this going concern sale under liquidation. So when it comes to going concern sale under liquidation, the concern majorly is that there are assets in the corporate debtor. If there is a viability of continuing that asset, that plant and machinery, whatsoever is there in the or the business of the corporate debtor, which is there in the corporate debtor, then the process of selling the corporate debtor as going concern has to be explored by the liquidator, because it is understood that if the liquidator sells the business of a corporate debtor or the corporate debtor as a going concern, then there is a possibility of value maximization. There is a possibility that ultimately the liquidator will end with realizing more value than it will sell than it will realize otherwise by selling only the assets of the corporate debtor. So there are two differences between the two: selling the business and selling the corporate debtor as going concern. What is the difference between the two? So the difference between the two is that when the liquidator is selling the business of the corporate debtor as going concern, that means that there are several business in the corporate debtor. One of the business is one or two of the business of the corporate debtor in such a position that can be sold by way of going concern. There are other assets as well which otherwise cannot be sold as a going concern because of the litigation attached to it or because of the other contingency which are attached to it. So if there is a possibility of selling one of the businesses, then that particular possibility should be explored by the liquidator. In case of corporate debtor, selling the corporate debtor as a going concern, the entire business of the corporate debtor along with the corporate shell of the corporate debtor is being sold as a going concern. So here the basic difference between the two is that when the liquidator ends with selling one of the business of the corporate debtor as going concern, what is left behind is the other business and the corporate shell. In that case, the liquidator is required to make an application to the adjudicating authority for dissolution of the corporate debt once the other assets are also realized. On the other hand, when it is about selling the corporate debt as a going concern, then without realizing individual assets, the liquidator is selling the entire business along with the corporate shell. In that case, the liquidator is not required to take approval of the NCLT for the dissolution, or not required to move the corporate debtor towards dissolution, but to inform the adjudicating authority that the process is complete, and this is the way in which the process is complete. This is the way in which the corporate debtor along with the corporate shell is being transferred to the acquirer. Now, as I was discussing the meaning of corporate debtor as going concern provided in accounting standard, what is the relevance of discussing the same? Because it often come under the consideration of the acquirer, that they always say the liquidator to prepare the accounts. Once the corporate debtor has been sold to the acquirer asks the liquidator for the intervening period account. There the concern arises as to whether the liquidator should treat the corporate debt as going concern during this liquidation process as well, and accordingly prepare the accounts for this intervening period as well. Like otherwise the normal companies are required to prepare the accounts on going concern basis, or the accounts to be prepared will be different from that of the normal liquidation account or normal company's account. If we see the definition of going concern provided in accounting standard 1, it says that going concern implies that corporate debtor would be functional as it would have been prior to initiation of CIRP. other than the restriction put in the code, and that the corporate and that the enterprise has neither the intention nor the necessity of liquidation or curtailing materiality of scale of operation. So here it is particularly disclaimed that there is no possibility or there is currently no such circumstances that the corporate debtor will lead to liquidation, and therefore the accounts is prepared in that manner, wherein profit and loss account, balance sheet, etc. is prepared. However, when it comes to going concern during liquidation process, well, there is no particular definition provided in the law. But if we see the discussion paper, which was there at the time of introduction of this section in the provision, that discussion paper particularly deals with the aspect as to when a corporate debtor can be called or can be said to be a going concern. There it is written that going concern means all the assets, tangible, intangible resources needed to continue to operate independently a business activity which may be whole or a part of business of a corporate debtor without value being assigned to the individual assets or resources. So here we are not providing individual value to individual assets because we are not selling the assets of the corporate debtor only. Here we are selling the entire business of the corporate debtor along with the corporate share. So when this option is explored, it is called going concern. Here concern again may arise that there may be a situation where there's a plant in a business, but that plant is shut for a while. Can we say that the corporate debtor is going concern? So yes, we can see the corporate debtor as a going concern only when there is a possibility that with some fuel from the stakeholders and from the intervention of judiciary, the corporate debtor can still be revived by the new acquirer, not by the erstwhile management, but by the new acquirer. In that case as well, we can say that the corporate debtor is going concern and the liquidator can explore this process of going concern. So this going concern under IBC, this concept of going concern, as we all know that winding up process was there in Companies Act 1956, was there in provision of Companies Act 2013 as well, and ultimately IBC was introduced. In all these erstwhile provisions, in all these law as well, in the erstwhile Companies Act 1956, in the provisions of Companies Act 2013 as well, there was going concern. There was a discussion of going concern. However, these sections never notified. At the time when IBC was introduced, initially the concept of this going concern cell was not there. However, section 20 was there, which particularly says that the IRP, RP, or liquidate as the case it is required to maintain the corporate debtor as going concern. So that particular maintenance of corporate debtor as going concern concept was there, but the cell of corporate debtor as a going concern was explored later on in 2019. After several discussion on this topic, that if the corporate debtor has the possibility of revival, then it should be revived by way of the chance should also be given to revive the corporate debtor by way of going concern cell, and so that this particular process can fetch more value to the liquidation state. Now, if we say that corporate debt is a going concern, then in what circumstances we can explore this process? What are the ingredients that has to be there in a corporate debtor to call it as a going concern? So there has to be a continuity of the business, erstwhile business which was there in the corporate debtor prior to commencement of liquidation process. That business, there has to be continuity of that business. There has to be some stock. There has to be a premises. I'm not saying that all this has to be there, but either of them should be there to say that there is something that can be continued later on by the acquirer. So I cannot sell the empty dabba to the acquirer that, see, this is going concern. So whatever I'm selling as a going concern, that should have the possibility of continuation by the new acquirer. So there has to be something inside it, apart from that mere corporate shell. Say, suppose if there are assets, then there has to be some license attached to it. There are contracts, etc., benefit of which can be fetched to the acquirer. So if there is a plant and machinery, at least should be in workable position that can be started. There are staffs there has to be some possibility that those staffs who are trained staffs who know how to continue the business or how to run the plant, etc., they can continue with the new acquirer as well. The business name of the company that has certain goodwill, etc. So that name can be continued with the new acquirer. So there has to be certain ingredients which should be attached with the corporate data that can be sold to the acquirer. Now the concern arises as to why going concern sale. Why is it preferable? Whereas it is preferable but not much explored till now, because just we have seen that there are only 47 cases wherein going concern sale has been explored and order has been passed by the adjudicating authority. So why going concern sale is preferable? I'm continuously saying that it may fetch comparatively more value than selling the assets by way of slump sale, and therefore there is a concept of value maximization, because of which the going concern sale should be preferred by the liquidator. So here it is that why going concern sale? The concern is that the concept is that it may fetch a better utilization of resources. There may be a more value maximization. The company will survive as it was surviving. So the company will survive, of course, with the new management, with the new acquirer, with the new promoters introduced to it. There will be a retention of workman and employee, given that the workman and employee who were there in the corporate data earlier or were associated with the corporate data earlier were well trained with the the business that the corporate data used to do with, and therefore that the acquirer can get benefited from those workmen and employees. If there are certain assets which are on lease, say suppose the premises or the land in which the plant and machinery plant is situated of the corporate data, if that is on lease, so that lease period will be transferred to the acquirer. So for that remaining period of lease, that benefit can be given to the acquirer. There may be a better incentive for the proposed buyer. The court also, in fact, it has also been seen that courts also prefer going concern sale initially. There are several orders like Edelweiss order, Gujarat NRE order, and several other orders as well, wherein it is clearly mentioned by the court to first explore the going concern sale, and thereafter the other modes of sale. So overall, we can say that it is necessitated, or it is one of the most preferable way for to explore by the liquidator, so that the ultimate value realization of the liquidation state can be comparatively more than otherwise than with the given other modes of sale. So now the question arises is, if we are exploring, if the liquidator is given a chance to explore the going concern sale, so is there any particular timeline which is provided in the provision within which the liquidator can only go ahead with the going concern sale, or the liquidator can explore the process at any time? So the provision regulation 32 is there, which says that either going concern sale is recommended by the committee of creditors at the time of deciding for the liquidation process, when the committee of creditors ultimately decides that the resolution is not concluding with the resolution plan or not fetching a good value. In that case, the corporate debtor, the COC may decide that let the corporate debtor be moved to liquidation. At that time itself, the committee of creditors may decide as to what all assets and what all liabilities will be contributed to form a going concern estate, and accordingly the liquidator is required to realize the assets by way of going concern sale. If at all, say suppose the possibility is not explored at that time or not provided particularly in COC's resolution, in that case the liquidator is required to form an opinion as to whether at all the whether at all the liquidation process can be concluded by way of going concern sale or not. And when this when liquidator decides that corporate debtor should be moved ahead with the going concern sale, in that case the liquidator has to decide as to what all assets, what all liabilities will be there in the liquidation state that will be continued with the going concern sale. Why I'm using the word liabilities? Because we all know that liabilities, if any, has to be paid as per section 53 only. But in the discussion paper as well, the liability term is used. Here it is not about the otherwise liability, the stakeholders which are required to be paid as per 53. Here are the liabilities which otherwise the liquidator thinks that should go with the acquirer, or the acquirer intends to acquire those liabilities as well. So if at all there are certain liabilities like that, that particular liabilities can be clubbed with the assets of the corporate debtor and can be sold by way of going concern. The other modes, if at all, and there is a timeline given within which the going concern sale has to be explored. So the provision now says that in the first auction, going concern sale has to be preferred, has to be chosen by the liquidator. However, if in first auction the going concern sale fails, in the subsequent auctions, the liquidator is required to explore other modes of sale as well. So it is not that in the other processes or in the subsequent auctions, the option of going concern sale is not available with the liquidator. It is still available with the liquidator, since the same has been inserted by way of clarification in Regulation 32 itself, that the liquidator may explore going concern sale in the subsequent auctions as well. However, in the subsequent auctions, the liquidator should also be is also required to explore the other modes which are available for the purpose of realization of the liquidation estate. In the matter of Surinder Manchanda versus Nalsar International Limited, NCLT Delhi has particularly pointed out this part, that there is no bar on the corporate debtor as a going concern sale even after the first auction has taken place. The liquidator is not obliged to seek permission of adjudicating authority for conducting such sale. So there is no particular compulsion of the liquidator per se to have the going concern sale explored in first auction itself. Liquidator has the right, has this responsibility to have the maximum realization of the assets of corporate debtor or the liquidation estate, and therefore this possibility, the exploring the possibility of going concern sale in subsequent auctions are also available with the liquidator. There's another ruling of Supreme Court in the matter of International Finance Corporation versus Official Liquidator of Kolkata, wherein it was held by Honorable Supreme Court that there is no standard or uniform pattern to be followed for disposal of assets of corporate debtor and should be examined on case-to-case basis. So it is not particular as to how going concern sale will be continuing. If at all there is a contract, so if that contract is not continuing, can we say that the corporate debtor is going concern sale? If there are different businesses, there are litigation connected to it, how to explore the going concern sale option. So this is always open to the liquidator to decide as to what value it can fetch if the liquidator is sold by way of going concern sale. Mr. Avinash, I'll request you to kindly mute yourself, please.
हाँ ठीक है, मैं ते उसका नंबर भेजता हूँ तेरे को.
Maybe chapter institute can mute him.
Yes, I have muted, sir. Thank you.
Okay, please go ahead.
Thanks. So as we were discussing as to why going concern is preferable, that part I have already discussed, that going concern is preferable because comparatively it gets a better value than the other modes which are provided therein. And the difference between section 32E and regulation 32E and 32F also I have discussed in brief as to what is the difference when I say that sale of corporate debtor as a going concern sale, or on the other hand, when I say that sale of business of a corporate debtor as a going concern sale. So when I say that sale of corporate debt as a going concern sale, in that case, I am selling everything, including the brand, structure, entire business of the corporate debtor, the corporate shell, the legal entity, everything I'm selling as a going concern sale. When I'm selling the business of a corporate debtor as a going concern sale, that means that I am selling, that means there are more than one businesses in the corporate debtor. I am selling one of the businesses of the corporate debtor as a going concern sale. And in that case, after realizing the remaining business as well, the remaining assets as well, the liquidator has to take the initiative to file an application to the adjudicating authority for dissolution of the legal entity, which otherwise, in case of sale of a corporate debt as a going concern sale, is not required. In that case, the liquidator is required to file an application with the adjudicating authority for confirmation of sale and not for dissolution of the corporate debtor. Because in that case, the corporate shell of the corporate debtor is also sold to the acquirer. Now, what are the benefits?
May I ask a question?
Yes, sir, please.
Sale as a going concern with the legal entity, or sale as a going concern with only for the business. So there is a difference that you have rightly mentioned that if it is with the branch or without the branch. Like say if I have 3 number of assets, one is at Kolkata, Delhi and Mumbai, and I want to sell the company as a going concern, but there are 3 buyers who are taking the company as a going concern for 3 different cities, and they want to buy the product, buy the company along with the brand also. So how to differentiate that it will be sale as a going concern with, because you can say that all the 3 cities have 3 different brands.
So if there are 3 different buyers, so there will be 3 different agreements. You cannot sell the corporate shell particularly to anyone. Every rights to every business is attached particularly differently. So it is not that everything is being sold to one buyer only. So here you are selling the business of the corporate debtor as going concern sale. And law says that whenever you are selling business of a corporate debtor as going concern sale, in that case, the legal entity has to be dissolved. So if at all you are, say, suppose you have sold 2 businesses of corporate debtor as going concern sale, then there is one business which remains with the corporate debtor. And at the end, when you are selling the last business, you are also selling along with that business the corporate shell as well. In that case as well, you can say that the corporate debtor is being sold along with the corporate shell and the dissolution is not required. So that may happen. So at the end, at least you have to sell the corporate shell as well. So that is important. So you have to decide.
Can I sell the assets to 3 different buyers along with 3 different brands?
So corporate shell is one only. How can you bifurcate the corporate shell between the 3?
No,
So
that is my question is, like say in Kolkata, I have a branch say ABC. In Mumbai, I have a branch say XYZ, and I want to sell both the assets of the company to 2 different buyers along with the separate brands ABC and XYZ. So can I say that I'm selling as a business of the city as a going concern under Regulation 32F along with the brand of ABC to Kolkata buyer and XYZ to that Mumbai buyer?
So sir, you yourself have said that you are selling the corporate data under Regulation 32F. When you are using 32F, in that case, there is no question of confirmation. There is a question of dissolution. So there will be no corporate entity. The legal entity will not be dissolved. The legal entity will not be retained. That has to be dissolved. So you are selling the corporate data, the business, the one branch, the other branch, you are free to sell by way of 32F. But the legal entity which ultimately will be there, that has to be dissolved. Ultimately, there is nothing in the legal entity, but that legal entity has to be dissolved.
No, but my question lies only there. I think in between the line only. So I am selling the business of Kolkata along with the brand name of ABC. But the brand name of ABC is registered along with the entity. So I am dissolving the entity. There is no issue. But can I get the relief from the NCLT that so and so legal entity will be dissolved, but that brand will be taken over by so and so company?
So 32F is about that only. So otherwise, it would not have been called as a business of a corporate debtor as a going concern. You would have sold it by way of slum sale as well. Because in slum sale, there is no question of going concern. You are just selling the assets of the corporate debtor only. When you are saying business of a corporate debtor as going concern, that means you are selling the assets along with the license contracts, whatsoever attached to it as well. So you are selling the business along with the license business contracts attached to it to the particular acquirer for, say, suppose Kolkata branch. Likewise, you are selling the assets along with the license contract whatsoever attached to it to the Mumbai branch as well. Now, ultimately, the corporate shell is still surviving. So that corporate shell, after selling these 2 businesses, has to be dissolved, has to be led to dissolution. So you are exploring 32F. 32F is different from that of slum sale. So in case of slum sale, you are selling only assets. In that case, there is no contract, there is no license, nothing is getting transferred. Only the asset will get transferred.
Okay.
Right?
Thank you.
Now coming to this benefits of selling the corporate debtor as going concern, as we have just discussed, that it fetch more value comparatively to the other modes which are prescribed for selling the liquidation estate. and therefore it is always provided by the adjudicating authorities as well to first explore this option to sell the corporate debtor by way of going concern only. So now coming to the other modes which are there, let us just quickly see the comparison between the other modes which are available for realization of liquidation state. So the other modes are piecemeal basis, slump sale basis, corporate debtor as going concern, and business of a corporate debtor as going concern. We'll quickly see the difference between the four as to what is the difference between the four. So the first is about transfer. When it is about piecemeal sale, any one or more of the assets is being transferred. So I'm selling the assets on piecemeal basis. One asset I'm selling to the acquirers, to the different acquirers. On slump sale basis, I'm not assigning value to any particular asset. I'm combining a bunch of assets and I'm selling the assets, but there I'm not selling any contractual rights connected to this assets. So that is slump sale. The other is corporate debtor as going concern, wherein corporate debtor itself is getting transferred along with all the contracts, rights, license, litigation, whatsoever is there, not litigation, but all the license contracts available to it, the assets, etc., which are there, everything is transferred along with the corporate debtor to the acquirer. On selling the business of a corporate debtor as going concern sale, here we are selling one or more business of the corporate debtor as a going concern sale, and the license contracts which are attached to that particular business is also getting transferred to the acquirer. Second is equity holding. So equity shareholders are always treated as stakeholders. They come in the section 53 Q. So they will be treated under section 53 all the cases. The retention of business in piecemeal basis, liquidator may carry on the business, the remaining business which are there. In slump sale, again, liquidator may carry on the business after selling the assets by way of slump sale, which is whatsoever is left behind, liquidator may continue with that. On corporate debtor or selling the corporate debtor as going concern basis, the acquirer is expected to carry on the business. So the acquirer is carrying on the business, not the liquidator. The other is business, selling the business of a corporate debtor as going concern. Here, the business that I have transferred particularly, that will be continued by the acquirer, and the remaining business will be continued by the liquidator. Then discharging of employees, when it comes to piecemeal, when it comes to slump sale, when it comes to other mode of sale, in that case, the employees are discharged. In fact, the liquidation order itself says that the passing of liquidation order is ultimate discharge of all the workmen and employees of the company, until unless some specific employees are retained by the liquidator for the beneficial liquidation of the corporate debt. So if at all there are some workmen, some employees which are kept by the liquidator for continuing the beneficial liquidation of the corporate debtor, in that case, those particular employees or workmen will continue. Otherwise, it is considered as automatic discharge of all the employees and workmen of the corporate debt. In going concern sale, generally, all the workmen, all the employees of the corporate debtor gets transferred or are acquired by the acquirer because those workmen and employees are trained with the business of the corporate debtor. So the acquirer do not have to give the entire efforts again to train the employees or train the workmen. So they get the trained workmen and employees and they can take advantage from them. So of course they can continue with the erstwhile workmen and employees of the corporate debtor. However, it is completely dependent upon the acquirer. In case of business of corporate debtor as a going concern sale, when a particular business is sold, so the workmen or employees, those who are connected with the particular business, they get transferred to the acquirer. In case of liabilities, all the liabilities are paid as per section 53 only. It is now clear in law as well that no liabilities will continue with the acquirer in either of the modes of sale. So all the liabilities will be paid under section 53 only. Encumbrances on assets. So if there is any encumbrances, any security interest, so that asset will be sold after relinquishment of security interest by the acquirer. Now there is a particular timeline of 30 days which is given to the stakeholder or to the particular creditors having security interest on the assets of the corporate debtor, that to either realize or relinquish. If you are relinquishing, that means you are giving your asset in the common pool. And once it is in common pool, then it will be realized and the value distribution will be as per section 53. So in all the cases after relinquishment, the liquidator is free to move ahead with the realization of the corporate debtor. And lastly, dissolution. So when it comes to dissolution, in case of piecemeal, of course, the corporate debtor goes into liquidation. In case of slump sale as well, corporate debtor goes into liquidation. And in case of business, selling of business of a corporate debtor as going concern as well, the corporate debtor gets dissolved. However, in case of selling the corporate debtor as a going concern sale, their corporate debtor is not getting dissolved. The selling of the corporate debtor by way of a going concern sale has to be reported to the adjudicating authority by the liquidator, and the liquidator has to take the confirmation of sale from the adjudicating authority basically. So there is no dissolution of the corporate debtor when it comes to selling the corporate debtor as a going concern. Now, as I said at the very initial stage of the very starting of the session itself, that in liquidation as well, there are two options given to revive the company or to survival of the company. So those options are, one is going concern sale and the other is scheme of arrangement. Going concern sale, we are discussing that it is about to realize or to sell the corporate debtor along with the assets, along with the contracts, license, whatsoever is there with the new acquirer. When it comes to exploring scheme of arrangement, so scheme of arrangement, as we all know, is particularly provided in detail in section 230 of Companies Act, 230 read with 232 of Companies Act. There particularly, the entire process is provided as to how the process has to be explored, how the approval is required to be taken from the members, from the creditors, from the adjudicating authorities, from the respective regulators, etc. Here, when it comes to IBC, the process is not provided in detail. So the clarity is still needed as to how to proceed ahead with this scheme of arrangement part when the liquidator is intending to explore the scheme of arrangement during liquidation process. So how to follow the process, because there is a particular timeline of 90 days provided. There was a discussion paper in which it was mentioned to reduce the timeline to 30 days. So not sure as to how within a period of 30 days, the entire scheme of arrangement will be explored during liquidation. So that process to be followed by liquidator during liquidation still needs clarity. There's no particular clarity about it. While some of the liquidators is exploring the process, however, the law as on date does not provide any particular clarity about exploring this particular scheme of arrangement during liquidation process. Now, going concern sale versus slump sale. Why I'm exploring going concern sale and why not slump sale? Or why I'm exploring slump sale and not going concern sale? So slump sale is about selling the assets only, not the license contracts otherwise which are attached with the corporate debt. I'm not selling those. Only the assets, a bunch of assets. I have combined the assets and I'm selling the assets of the corporate debt only without assigning individual values to the assets. However, on the going concern sale, I'm selling everything to the contract, to the license, whatsoever is attached with the corporate data, I'm selling everything. So why going concern sale or why not going concern sale? The concern here arises or that requires a bit of discussion as well, that there is no clarity on going concern sale. That we all know that in case of slump sale, I am selling the assets, the acquirer has acquired the assets. Now, ultimately, the corporate debtor will go for dissolution. But in case of going concern sale, I'm selling that license, I'm selling the contracts, I'm selling everything which is attached with the corporate debtor. So the acquirer has to have effort, has to give efforts to have those license, have those contracts transferred in his name. That is why it is still a bit difficult for the liquidator to explore this going concern sale, or not liquidator not getting much option, much exploration about this entertaining this going concern sale during the liquidation process. They are otherwise finding it more easier to realize the asset by way of slump sale instead of going concern sale because of this transitional difficulties. Now, effectuating going concern sale, how to give effect to the going concern sale? What will be the treatment of contractual rights? What will be the fetch of this workmen and employees who were there in the corporate debtor? How the assets or liabilities will be transferred? What will happen to the directorship? What will happen to the liquidation process which was going on? Whether at all the liquidator is required to comply with the compliances during the liquidation process as well. The transfer of potential realization of avoidance proceedings, what will happen to that? And ultimately the completion of the process versus resolution. So first is about treatment of contractual rights. If one finds that there are contractual rights as well, which otherwise, if survives, will give a better position to the acquirer, in that case, of course, it should be explored. The going concern process should be explored. Like in case of workmen employees, if at all there are workmen employees in the corporate debtor prior to initiation of liquidation process, and if there is a possibility that if we sell the corporate debtor by way of going concern sale, then the workmen or employees will also be retained by the acquirer. So in that case as well, it should be that liquidator should give the going concern sale first chance. Second is transferability of assets and liabilities. So all the assets of the corporate debtor will transfer to the acquirer. Liabilities will be treated or will be extinguished or will be basically treated as per section 53 of code. So all the assets of the corporate debtor will survive, but at what value? Because there are several assets in the books of the corporate debtor. Those assets I'm transferring on a lump sum consideration to the acquirer, along with assets I'm selling the contractual rights, the licenses, etc., to the corporate debtor and to the acquirer, and acquirer is fetching a value for everything. So how to distribute that values among the different assets of the corporate debtor? Whether the liquidator is required to fetch individual values against the assets of the corporate debtor, or whatsoever the liquidator has realized, the liquidator is required to put a lump sum consideration towards the entire assets of the corporate debtor. How to treat that in the balance sheet of the corporate debtor? Then changing the directorship. So erstwhile director will not survive. Erstwhile directors will not be there in the corporate debtor. Those directors, the power of board basically gets transferred to the liquidator, and ultimately once the liquidation process is complete, then the new acquirer is required to engage new management, appoint new management in the board of the corporate debtor. Then what is absolved in the liquidation process? What will be there in the liquidation process? How smooth this liquidation process will continue? Then the next option is, what about the compliances during the liquidation process? If say suppose I am exploring the going concern sale, or I am exploring the other modes. In CIRP, we all know that provisions are there that requires the IRP or RP, as the case may be, to comply with the requirements of other regulations as well during the CIRP process. However, when it comes to liquidation process, the law is silent still about these as to what the liquidator is required to follow. Whether liquidator is required to file the annual returns, whether the liquidator is required to prepare the financials of the companies, whether the liquidator is required to comply with the listing obligations, etc., which are otherwise applicable in case of a listed company. Nothing is provided in the law so far. No clarity is provided in the law so far, and therefore the corporate debtors which are ending with the going concern sale and those who are also listed are following a certain process. We have explored those processes as well. We have checked those processes to how different corporate debtor or the different liquidator are following processes, how they are concluding with the process of liquidation, going concern sale. So that we will discuss in a later part of the session. Then transfer of potential realization of avoidance transaction proceeding. So earlier it was there that even if the avoidance transaction proceeding is complete, that should not stop the liquidator from selling the corporate debt. Liquidator should still proceed ahead with selling the corporate debtor by way of a different mode of sale which are provided in the law. So the concern arises as to what will happen to the realization, if at all there will be any realization from the avoidance transaction proceeding, because the liquidator is required to file a separate application with respect to the avoidance transaction findings during liquidation process. So if at all there is any value realization to that, now the law also says that liquidator is, while filing the final report, the liquidator is required to mention as to how this avoidance transaction proceedings will be carried on post completion of the process. So that has to be decided in consultation with the stakeholder consultation committee as to how this process, this avoidance transaction proceedings will be continued after the selling of the corporate debt. And last is about completion of the liquidation proceeding versus resolution. So it is about if at all the corporate debtor itself is getting transferred, in that case, that will be completion of liquidation process. If at all the business of the corporate debtor is getting transferred, in that case, the corporate shell of the corporate debtor has to be dissolved. So there has to be a dissolution application to be filed by the liquidator. Now, the concerns, which is the main topic of today's discussion, is about managing the corporate debtors going concern sale. When it comes to managing the corporate debtors going concern sale, there are different aspects which come into the picture, like what will be, how to manage the workmen, employees, how to manage the benefit fund which are there for the employees and workmen, how to prepare the financials of the corporate debtor. If at all the liquidator is required to prepare the balance sheet and profit and loss account of the corporate debtor during liquidation process as well. Now, whether at all liquidator is required to conduct annual general meetings, whether at all the liquidator is required to file the AOC4, MGT7 and other annual returns during liquidation process, whether the liquidator is required to continue with the responsibility of management with respect to disclosure to the stock exchange if at all the company is listed entities. So whether those listing obligation or the SEBI regulations are also applicable in case of liquidation as well. And if at all the corporate debtor is listed, then whether that listing provision, that listing, the corporate debtor is listed, then whether the acquirer will also get benefit, whether that company will continue to be listed even after selling the corporate debtor as a going concern as well. So there are several concerns. So we'll try to explore, we'll try to discuss as to how these concerns can be resolved. Well, as I said, so far, law does not provide clearly as to how to do it. So it is still a trial and error. There are different liquidators who are trying to deal with this position. They are trying to treat the process based on the discussion paper, based on the rulings of adjudicating authorities, and based on the guiding principle from the adjudicating authorities' orders in other matters. So we'll explore those things now. The first concern is about treatment of workmen and employees of corporate debtor. So what will happen to the workman or employee of the corporate debtor? If I am required to manage the corporate debtor as a going concern, how to treat the workmen or employees? Whether I'm required to continue with all the workmen, all the employees, or I'm required to discharge all the workmen or employees from the duties like regulation, section 33 provides. Section 33(7) of the code says that the order of liquidation is deemed to be notice of discharge to the officers, employees, workmen of the corporate debtor, except when the business of corporate debtor is continued during the liquidation process by the liquidator. So if I think that the corporate debtor can be the liquidation process can be concluded by way of going concern sale, in that case, I also required to keep this in mind that whosoever will acquire the corporate debtor should also get a smooth transition of the process, smooth transition of the corporate debtor. Now, when I'm transferring the plant and machineries, when I'm transferring the business of the corporate debtor, if there are employees, if there are workmen who are otherwise trained with the business, who knows how this machinery runs, how to what otherwise fuel or what otherwise things will be required to run the factory, to run the business, where to get the fuel from, where to get the otherwise required ingredients that are there to continue with the business. So if those workmen or employees are there who are well aware or well conversed with the business of the corporate debtor, if I continue with those employees, so those employees will surely fetch a value to the acquirer, because acquirer is not required to start from scratch. Acquirer will get references from this workmen and employees and will be able to utilize their knowledge that they were there during the CIRP and before the CIRP process of the corporate debtor. So if at all the liquidator thinks that continuation with the employees, continuation with the workmen, certain employees, a group of employees, a group of workmen can fetch a better value to the acquirer, he may take a call to continue with those employees, those who are required to continue with the business. In fact, the provision also says, section 35(1)(e), that also allows the liquidator to carry on the business of the corporate debtor for his beneficial liquidation. So far, the liquidator thinks that if I continue with these workmen, these employees, this will have a beneficial liquidation. Liquidator can continue with those employees and workmen. In both the cases, employees are required to continue the business. Employees may not be discharged and should be ideally be transferred to the acquirer so that the acquirer can get benefited from this workmen and employees of the corporate debtor. Now, transfer of assets and liabilities of the corporate debtor. These liabilities word are used in the discussion paper. However, it is very, very clear in law now that liabilities will form part of section 53 only, will be released as per section 53 only. So the provision says that GCS, when a going concern process is undertaken, so there are two modes, either in consultation with the committee of creditors at the time when committee of creditor finally resolves that the company should lead to liquidation now and CIRP process is not surviving anymore. In that case, COC may decide as to what all composition should be there to first explore the going concern process. If at all the COC has not explored this process, is not discussed about this process, then liquidator is given the liberty to decide or this flexibility to decide as to what all assets, what all combination of assets should be there to treat the to explore the options of selling the business of a corporate debt as going concern sale or selling the corporate debt as a going concern sale. In each of the cases, in all these the measures, the ultimate idea is the value maximization. So that if at all the COC is not decided, then liquidator has to decide in consultation with the stakeholder consultation committee as to how to proceed ahead further with the realization of this liquidation estate. Then computing or exploring the assets or the combination of assets which can be combined together and accordingly be sold thereafter. Transfer of assets and liabilities of corporate debtor. So Supreme Court in case of Allahabad Bank versus ARC holding held that if company is sold as a going concern, then along with the assets of the company, if there are any liabilities which are relevant to the business or undertaking the business, that should also be transferred. So if at all there is certain liabilities, certain things which may fetch certain value to the corporate debtor, that should also be transferred. So that is completely upon the liquidator to decide as to what all liabilities should continue, or the acquirer may also say that this particular liabilities I am choosing that will be continued with me and ultimately will be paid by me separately and not as per section 53. All the components may not be crucial, so liquidators has the option to explore as to what all should be comprised to or should be consolidated to continue with the going concern sale when it comes to selling the corporate debtor or the business of a corporate debtor as going concern sale. And going concern sale in liquidation, that in general sense are, as I said, is different from that of the going concern sale. Otherwise, normally a corporate debtor is required to be maintained as a going concern. Is completely different from the going concern which is there during liquidation, because here going concern means that the company may not be in a position or may not be running for the time being. However, with bit finance from the stakeholder, with bit of intervention of the judiciary, it can be again back to the track or can be continued, can be survived by the acquirer. So if that position is there, then only we can say that the corporate debtor is a going concern. Share capital of corporate debtor. What happens to the share capital of the corporate debtor? So as I said, that shareholders of the corporate debtor are also the stakeholder. They also are required to come into the queue of section 53. At the end, towards the end, the share capital, the equity shareholders are there. So there's no question of share capital remaining in the books of corporate debtor. when it comes to transferring the corporate debtor to the acquirer ultimately it is seen in several going concerns processes that has happened so far, that whenever the corporate debt is being sold as a going concern, the acquirer files an application with the adjudicating authority, asking or seeking certain reliefs from the adjudicating authority. One of the relief is that extinguishment of share capital and issuance of new share capital. So how much new share capital will be issued, that has to be decided by the acquirer. The existing share capital will be extinguished. So there will be no continuation of the share capital, because the ultimate claim of the share capital will come into the queue of section 53. And the acquirer will decide as to how much new shares will be issued post acquisition and post having the order of NCLT in hand. So again, there are two different. The first is about the selling of corporate debt as a going concern, selling of business of a corporate debt as going concern sale under regulation 32E and 32F. So when it comes to 32E, the transfer along with assets and liabilities, including all the contracts, license agreements whatsoever, get transferred to the acquirer. The consideration what is received from the acquirer, that is split into two parts. First is about the share capital, the other is about the liabilities. How much to give to share capital, how much to give to liabilities, that is to be decided by the acquirer. So ultimately, acquirer decides to how the balance sheet will look like once it is acquired by the acquirer. And there will be issuance of shares by the acquirer. The acquirer will issue new shares post acquisition. The existing shares will get transferred, will get extinguished, and the existing shareholders will become claimant when it comes to regulation 32E. When it comes to regulation 32F, business along with the assets and liabilities, including tangible assets, these are getting transferred without transfer of corporate debt. So here the corporate debt is getting dissolved. When the corporate debt is getting dissolved, then the balance sheet, preparation of balance sheet is not coming into the purview of liquidator. So liquidator is not required to prepare any balance sheet, and there will be altogether new balance sheet which will be prepared by the acquirer ultimately. So here also the share capital is getting extinguished, and the remaining assets which are there, that assets is required to be realized by the liquidator by using the other modes which are there to realize the assets of the corporate. Now, second concern is about changing the status of corporate debt. So when the company is going into liquidation, the status of company changes from active to inactive or active to liquidation. How this change of status is happening and what is the relevance of this changing of status? So basically, there is nothing provided in law as of now that the status will change, but there is a MCA circular dated 6th March 2020 that requires the IRP, RP, or the liquidator, as the case may be, to file one form, which is GNL2, by adding themselves therein as a CEO, and file that form with the order of CIRP or with the order of liquidation, as the case may be, with the registrar of companies, and also to intimate the same to the IBBI, so that IBBI can also get in touch with the registrar of companies and can ask them to change the status of the company from active to liquidation. So what happens is, once the company is under liquidation, then no particular form will be filed or can be filed by the liquidator or anyone else. Only GNL2 is the form which can be filed even after the company is gone into liquidation. So GNL2 is the only form which can be filed. So if at all there is any particular form which is required to be filed during continuation of this process, those forms can be filed by way of GNL2. Here also, as the topic is about managing the corporate debt as going concern, and we were discussing is whether at all the annual returns, the AOC4, MGT7, etc. is required to be filed by the liquidator or not. So we have seen that in some of the cases, the liquidators are filing AOC4 and MGT7 by way of GNL2 form during liquidation process as well. And in some of the cases, we have seen that liquidator is not filing any particular form during liquidation process, because law specifically does not require the liquidator to file any form during liquidation process, and hence the different practices are approached by the different liquidator. So this is the scenario as of now regarding the status of the corporate debt. Now coming next regarding statutory compliances. When I'm saying statutory compliances, again, there are three things. One is about form filing related, the other is about stock exchange related, and third is about IT return. I'll discuss about these three separately. So as of now, if anyone has any question, I'll like to invite question till now. If at all there is any question, I think there are some questions given in the chat box. NCLT order mentions sales of corporate data as NCLT order mentions sale of corporate data as corporate data, but SCC directs to sell assets separately first and going concern in later stage. This is no violation of order. So the idea to explore the going concern sale is to value maximization, and NCLT always asks to first explore the going concern process. In fact, the law also says that in the first auction only you have the liberty to try only going concern sale. And thereafter, in the subsequent auctions, you, along with the going concern sale, you are also required to explore other options as well. If SSC thinks that, so SSC is nobody to direct here. Please understand that when the company is during CIRP, then the IRP or RP is driven by COC. For everything, the RP or IRP is required to take consent of the COC for exploring whether to explore this mode, whether to how to invite claim, how to keep the value, how to treat the valuers, etc. What should be the fees, etc. So everything has to be determined by the COC. When it comes to SCC, Stakeholder Consultation Committee, as the nomenclature itself says, it is consultation committee. Here, liquidator is required to take consultation from the committee as and when required. Now, law, of course, requires that if at all there is any difference of opinion, then liquidator is also required to record the reason as to why the opinion is different. But there is no such compulsion on the liquidator to continue with whatsoever is directed by the SCC. So if at all the liquidator thinks that exploring going concern is more vital than going with the other options, then liquidator is free to take this call. The other question which is there is, other assets are sold, what to do with the recovery suits filed by the corporate debtor before CIRP liquidation proceedings and continuing without any headway. Also the suits against the corporate debtor in various tribunals and courts. Can we file dissolution pending these suits? If we can, what all need to be done? So basically, of course, this is one of the major concerns that I believe that all the liquidator are facing, that even if the process is continuing before one forum, which is NCLT, there are several other applications which are continuing before several other forums as well. In labor court, in city civil court, in other courts, there are several applications which are filed by the other stakeholders, workmen, employees, etc., and several other forums as well. So how to continue or how to deal with it? Liquidator cannot be expected to have the entire proceeding in hand as to what the erstwhile management has initiated or has continued or has filed before that particular forum. In fact, the liquidation order itself says that no proceeding can be started or can be continued with during the liquidation process. So because there is a moratorium during the liquidation process, so those proceedings cannot be continued with during the liquidation process. If at all there is any claim of any of the government authority, any of the regulator, that has to be filed as a claim before the liquidator. Otherwise, there is no such role the liquidator is required to play, because those applications were filed by the erstwhile management. And the erstwhile management is in a better position to answer as to why that particular appeal or application was filed or replied to at that time. Liquidator is not in a position to reply to them or to continue with this. So if at all there is anything continuing with the same, what max liquidator can do is to inform the respective regulatory authorities regarding the initiation of the liquidation process and to continue with the liquidation process, like realizing the assets, distributing the realized proceeds, and ultimately informing the adjudicating authority that what all has been realized, how the realized process has been distributed, and what all litigation, what all things are pending before different forums. So that should be captured in the final report. Otherwise, the liquidator is not required to continue with those proceedings before different forums. Otherwise, it will be very difficult for any of the liquidator to continue with or to conclude the process, basically. Now coming to this, filing of this AOC 4 or MGT 7 form by way of GNL 2. So these forms, as I said, that MCA circular particularly provides that there is a GNL 2 form, and that through this GNL 2 form, these forms, this AOC 4, MGT 7 can be filed by the liquidator, and this GNL 2 form still continues during liquidation process as well. So during liquidation process as well, if at all the liquidator is required to file any particular form, that forms can be filed by way of GNL 2. Otherwise, there is no compulsion as such, and the provisions so far does not provide any particular forms to be filed by the liquidator. Otherwise, then INC 28, Form INC 28, which is to inform the registrar of companies regarding the initiation of process or conclusion of the process, so that the effect of the same can be given by the registrar of companies at the MCA portal. Coming to the stock exchange filing related compliances. So unlike CIRP, nothing is provided for liquidation process, that whether at all the liquidator is required to inform or disclose the stock exchange regarding the regarding what is happening in the liquidation process from time to time in case of listed entities. So there is no SOP provided by any of the stock exchanges, neither the law, neither the PIT regulation or SAST regulation or SEBI LODR regulation particularly requires or particularly provides for the disclosure or the process to be followed by liquidator during liquidation process. So far, there is nothing. When it comes to IT return filing related things, so liquidator, whether at all liquidator is required to file the income tax return or not. There was one order of NCLAT wherein it is clearly mentioned that liquidator is not required to file any income tax returns. But practically, it is not possible. Liquidator is also required to file the income tax return. Why so? Because there may be a situation of liquidator ending with earning income during the liquidation process. What income I'm talking about? The income is about, say, suppose there is certain rental income or something which otherwise the liquidator is receiving during liquidation process. Say, suppose the liquidator is receiving some interest income during liquidation process. So those incomes are required to be reported, and accordingly, the liquidator is required to file the income tax returns. Otherwise, as well, if at all there are losses in the books of the corporate debtor, so that benefit of carry forward of losses will not be continued with the new acquirer if the liquidator is not filing the return. So the income tax return at least should be updated so that the benefit of that carry forward of losses or unabsorbed depreciation can be transferred to the new acquirer in case of going concern sale. See, we have seen in many cases that the acquirer are interested in acquiring the corporate debtor as a going concern mostly because of taking advantage of that losses in the books of the corporate debtor. So what they do is they acquire the corporate debtor as a going concern sale. They take advantage of that loss which is shown in the books of records of the corporate debtor, and ultimately they merge that particular acquired corporate debtor with them so as to take benefit of that losses. If at all they'll not be able to take benefit of the losses, then this possibility of exploring the corporate debtor as a going concern sale will go down further. As of now, we are seeing that there are very few cases wherein this corporate debt, selling the corporate debt as going concern sale has been explored. Further, if at all this particular is this option of not transferring the benefit of carry forward of losses is given to the corporate debtor or the new acquirer basically, then this possibility of exploring going concern sale will further reduce. So IT return should be filed by the liquidator during the liquidation process as well. Then preparation of financial statement. This is a very interesting question, and often this question is referred to in all the.
One more, please.
Yes.
As far as the income tax is required, liquidator is not required to file any income tax return. The only thing is when you are selling it as a going concern, then only the company will be continuing, and then only the liquidator or the new incumbent will be filing the return. And there is a case law also. In one case, one asset was sold out, and during the sale of assets, the property was sold out to someone, and he was required to deduct TDS. Then this in that particular company, they went to NCLT and they mentioned that since the liquidator is not required to file the return, and the company is going to be dissolved, then how the TDS will be enjoyed? Actually, TDS is nothing but the payment of tax which can be recovered in future when one files the income tax return. Since the liquidator is not going to file the return, then how will we get the refund of the TDS? And if we have to file income tax return, then it will be filed after 1 year. So I am selling the assets in the month of May, and I have to dissolve the company now. And if I am dissolving the company now, then how will I file the return for March of the next year? And then I will have to wait for 1 more year. This is not the IBC requirement. So it is the contravention of the IBC. Then NCLAT has passed the order that since the liquidator is not required to file any return, so it is not to be deducted.
Sir, you have mentioned that liquidator is not required to file the return. Now, explore a position wherein liquidator is having income during liquidation process as well. If at all during that process as well, if liquidator is not filing the income tax return, will it not be treated as violation of the provision that liquidator is having the income, but that income is escaping the necessary assessment which is required otherwise?
Yeah, as regards this is concerned, I think it's clearly mentioned in the income tax law itself that liquidator is not required to file. Number one is there is no surplus assets. Whatever I am selling, that will not be having more than the value of the assets. I will be selling, say, one asset, but the ultimate value would be lesser than what I have to pay. If there is
which section? I'm sorry, sir, I'm just intervening here. As to which section you are referring to by saying that?
I can, of course, I don't remember as of now, but I will of course within 5 minutes I will let you know.
Because sir, there is section 178 of income tax.
Yeah, 178 only.
That requires the liquidator to inform the income tax department regarding commencement of the liquidation process and to ask the income tax department as to if at all there is any due. So that is about due till the liquidation commencement date. So if at all there is any due till the liquidation commencement date, that will form part of the claim. So that will be treated as a claim and that will be paid as per section 53. So that is as on liquidation commencement date. But if at all there is any income post liquidation commencement date during the liquidation process, that should be assessed and that should be reported to the income tax department. So while there was one particular order, as I referred, of NCLAT, wherein it was mentioned that income tax, that liquidator is not required to file the income tax return. However, there are several other rulings as well, where it is specifically mentioned that liquidator should file the income tax return during liquidation process as well. If at all there is income, there is any TDS return, TDS deducted by the liquidator, because these TDS deducted by the liquidator, TDS deducted on the fees of the liquidator, what is happening to this? Where exactly these are reported, if at all I am not filing the income tax return. So ideally, there is no particular section that says that liquidator is not required to file the income tax return. If you see the provision of section 178 as well, it is not mentioned that liquidator is not required to file income tax return. Liquidator is required to file income tax return. However, 178 is about intimating the income tax department and asking the income tax department about their dues as on the liquidation commencement date. Now coming to this part of preparation of financial statements. So I was saying that this particular part is very important because it is often seen that the acquirer, after acquiring the corporate debtor, files an application with the adjudicating authority seeking several reliefs for smooth transition of the corporate debtor or for smooth transition of the business of the corporate debtor. So one of the prayers which is always mentioned in all these applications filed by the acquirer is regarding preparation of financial statements. They seek prayer that liquidator should be directed to prepare the financial statement as on the date. But the concern is that in the law, the liquidator is required to prepare receipts and payments account only. If the law does not require me to prepare the financial statement per se, nothing provided in the Companies Act, nothing provided in the IBC as well, that liquidator is required to prepare the financial statement as well. So how the liquidator will prepare the financial statement? Because the liquidator is required to prepare receipts and payments account on cash basis. There's the liquidation estate given to the liquidator. The liquidator is required to analyze as to what is there in the liquidation estate. Liquidator is required to explore the modes in which these assets inside the liquidation state can be realized. After the realization of this liquidation state, the liquidator is required to distribute the realization in the manner provided in section 53 and to give the entire detail of this realization and distribution in the receipts and payments account and submit the same to the adjudicating authority. This is the way in which the assets are realized. This is the way in which liabilities are paid off. And this is the way the liquidation process is ultimately concluded. So it's cash basis transaction, which is required to be reported in receipts and payments account. Section 35 says that under section 35, there's no duty which is prescribed for liquidator to comply with the requirement of filing of this financial statement. Under regulation 6, sub-regulation 3 of liquidation regulation, it says that the liquidator is required to maintain the register and books in the form indicated in schedule 3 with the modification as liquidator may deem fit. And therefore, in IBC, the liquidator does not have any specific obligation for the preparation of audited financial statement. Likewise, if we see the provision of Companies Act as well, section 137, section 92, there's no particular responsibility given to the liquidator to file, or no particular duty given to the liquidator to file the financial statement. However, if the corporate debt is prepared to be sold as a going concern during liquidation, in that case, it is ensured that books or accounts of the corporate debtor are updated so that the acquirer can also have a smooth transition. Why so? Say suppose the liquidation process of a corporate debtor started in 2018 and it took, say suppose, about 3-4 years for the liquidator to conclude the process. So since initiation of the liquidation process till the continuation of this liquidation process, just 3-4 years, the liquidator has prepared only receipts and payments account and no balance sheet isn't prepared. Accordingly, in the MCA data as well, the position of the filing of financial statement is shown as 2018. That is till the last financial statement filed by the RP with the registrar of companies. So dragging the financials from 2018 till, say suppose, 2024 will be a difficult task from the for the acquirer, and therefore some of the liquidator are following this practice to simultaneously preparing the financial statements as well. However, I again say that there is no particular compulsion. The law does not require the liquidator to financial statement. Some of the liquidators are following this practice to prepare a financial statement for the smooth transition of the to the new acquirer as on the date of sale. So during the liquidation process, they are preparing receipts and payments account only. When they are selling the corporate debtor, at that time, as on the date of sale, they are preparing one account in which they are giving the details as to how the share capital of the company is getting extinguished. The total amount which is received from the acquirer is shown on the balance sheet asset size and is divided into tangible and intangible assets in the manner as required by the acquirer. This part was also discussed in the discussion paper as to how the value will be divided between the assets of the corporate debtor. That has to be decided by the acquirer. How the amount, what amount should be shown on the share capital part, because the existing share capital will get extinguished. That has also to be decided by the acquirer. So in discussion with the acquirer, the liquidator prepares the account as on the date of sale and ultimately gives the same to the acquirer. And then acquirer carries the same forward, prepare the subsequent financial statement post the acquisition of the corporate debt. Now, that's the practical concerns regarding managing the corporate debt as going concern sale. Whether liquidity is required to prepare financial statements. As I said, there is no compulsion, there is no provision that particularly requires the liquidator to prepare the financial statement. So during the liquidation process, the liquidator is required to prepare receipts and payments account and not the financial statement otherwise. But some of the liquidators are following the practice to prepare the financial statements as well and filing the same by way of GNL2 with the registrar of companies. Whether the liquidator is required to conduct AGM. So AGM is about general meeting of shareholders, given that there are no shareholders, particularly because the shareholders are also becoming the claimant here. So there is no compulsion on the liquidator, or there's no requirement at all in the liquidator to conduct the AGM during liquidation process. Whether liquidator is required to file AOC 4 or MGT 7. Again, there is no particular provision so far in the law that requires the liquidator to file the AOC4 or MGT7. However, there was one MCA clarification wherein it was said that AOC4 or MGT7 can be filed by IRP, RP, or the liquidator, as the case may be, by way of GNL2. So if at all the liquidator intends to file the form with the registrar of companies, they may file the same by way of GNL2. In some of the cases, we have seen that liquidator is diligently filing the AOC4 and MGT7 by way of GNL2. However, in most of the cases, we have seen that liquidator is not filing these forms with the registrar of companies during liquidation process. What will be the status of listed companies? With the listing status will continue? The question is no, because share capital will not be there. What is listed? Equity share is listed. So if the shares is not there, what will be listed? So there will be no continuation of this listing license. If at all the acquirer intends to continue with the listing, then the acquirer has to fresh apply to the stock exchange for this continuation of this listing status of the corporate debtor. What will be the treatment of share capital and liabilities of the corporate debtor post going concern sale? So the share capital and liabilities, the share capital will get extinguished and liabilities will be paid off as per section 53 of the code. Whether liquidators required to take approval of NCLT before proceeding with the going concern sale? Answer is no. Liquidators not required to take approval of the adjudicating authority before exploring going concern sale, but after exploring the going concern sale, liquidators required to inform the adjudicating authority as to regarding the confirmation of the going concern sale, that going concern sale is the corporate debtor has been sold by way of going concern sale. Ultimately, the amount has been realized, and the manner in which the corporate debtor has been sold and amount has been realized and the process has been concluded. So for all those, for the confirmation of the entire process, the liquidator is required to file confirmation application. In case of selling of the business of the corporate debtor, the liquidator is required to file dissolution application because the corporate shell of the corporate debtor still survives. So for closing the corporate shell, the liquidator is required to file dissolution application with the adjudicating authority. Whether the liquidator is required to comply with SEBI regulations during liquidation. So as I said, there is no particular clarification in this regard. Law so far clarifies only during CIRP process what is required to be complied with. In fact, it is also provided in LODR regulation that the liquidator, that the during the resolution plan, during the implementation of resolution plan as well, the necessary information is required to be given to the stock exchange. Necessary disclosure is required to be made to the stock exchange. However, nothing is provided with respect to liquidation. Whether at all the liquidator is required to inform anything to the liquidator, to the stock exchange or not, nothing is provided in that regard. However, as a matter of caution, of course, at the time of initiation of the process, at the time of initiation of the liquidation process, the order of liquidation should be given to the stock exchange and SEBI as well, that this company is now moved to liquidation. What will happen to the employees benefit fund post liquidation? If at all there is any employee benefit fund, so these are not part of liquidation estate at all, as section 36 itself says that these employees benefit fund like gratuity, provident fund, pension fund, these are out of liquidation estate. So something which is not within the domain of liquidation estate is not within the domain of liquidator. Liquidator has no right on the same. So that has to be treated separately and that will not form part of the liquidation. So this is all from my end regarding the managing of corporate debtor as going concern sale. Now I'll ask the participants if they have any questions, they may please ask the questions.
Yeah, I just want to convey my in the case of S. Kumar's, Mr. Om Prakash was the liquidator therein, and he went ahead that no income tax return has to be filed by me, so no TDS should have been deducted. And it was CLET has given decision in favor of the liquidator that no return has need to be filed and no TDS to be deducted. Thereafter, on several occasions, it has been there, and that particular case has been referred by many persons, many liquidators. And I can see one case in the year 2023, wherein Vedanta purchased some property, and TDS was also deducted therein, but the return was not filed in the case of Nico Extrusions Limited. Versus Nicomet Industry Limited. The order was delivered on 17th of October 2023. And this liquidator informed the income tax department that so and so TDS was deducted and you have to refund the amount. And without filing the return, he wanted the return of the TDS amount. And this order was placed that within 1 month of the intimation to the income tax department, this TDS amount should be refunded. Otherwise, how will the liquidator will distribute the assets to the stakeholder as per section 53? So this is the requirement of the IB code that whatever assets are there, that has to be distributed before all the stakeholders under section 53. So this is the main crux by which so many judgments are there, and no return need to be filed by the liquidator. So if you can show me.
Sir, while law, I'll still stick to my point that law does not specifically requires that liquidator is not required to file the income tax return.
That has been mentioned here. That has been
Yes.
mentioned here in the enclave order and these orders that
Yes.
nowhere in the IB code there is mentioned that the liquidator need to file income tax return. And it is also mentioned in the IB code that whatever amount has been received, whatever amount has been collected or realized, that has to be distributed to the stakeholder under section 53. And the law is also there under IB code that liquidation period has to be completed within a period of 1 year. So if there is an inconsistency between two law, then this law will prevail. Section 238 of IB code is very clear that if there is any inconsistency, then this law will prevail. And after considering all these facts and figures, both this enclave in the case of this Kumars in the year 2020, and thereafter so many judgments are there. And lastly, I can find in the option of this 2023. This order is also there. It is NCLT Mumbai bench order. I can provide you the IA number 1634, CPIP number 649 of this is there. So just for the knowledge that no liquidator is not required to file the income tax return, but they have the right to claim the refund and to claim the refund whatever amount has been deposited by the purchaser of the property to the income tax department from the income tax department.
So while you are referring to some of the cases, there are several other cases as well wherein NCLT, NCLAT and other adjudicating authorities have referred that there is no particular exemption to the liquidator from filing the income tax return. There are cases of NCLT Hyderabad, NCLT Kolkata, NCLT Mumbai as well, where it is clearly mentioned that there is no particular exemption given to the liquidator from filing the income tax return. As regards the refund that you are referring to, I believe that you are referring to the refund that pertains to pre-liquidation period.
No,
so
during the liquidation.
During the liquidation process, sir, if at all you are not filing any return, how will the refund will be provided by income tax department?
That is what I am telling you. It is mentioned that during the course of the liquidation, one asset was sold out during the course of auction. Auction sale was there, and Vedanta Limited purchased the assets, and those whatever assets they have purchased, they deducted TDS of 1%. And by deduction of TDS of 1%, they made deposit of the TDS also to the income tax department. Then the liquidator did not file the return. The liquidator approached the income tax department and stated that so and so TDS was deducted from my account, and now you have to refund me the amount. So, it was the case like in the month of June or July, the liquidation was complete. So, if he has to wait for next year till April or May to file the return and thereafter to get the refund, then again, yes, this process will not be completed for more than 1 year again, and just for the procedural effect. So that is the reason he did not file the return, and he wanted refund of the amount which has been deducted by the Vedanta Limited for purchase of property through auction during the liquidation period.
And NCLT, you are saying that has granted that particular relief.
That order is before me only. I'll just open the order.
You can please give the link of that order, sir. I'll go through with that because there are several orders wherein it is also mentioned that there is no particular exemption given to the liquidator from filing the income tax return during
there are controversies also there.
Right, sir. Is there any other question other participants have? Anjali ji, if you are there, I believe if at all there are no questions from other participants, then we can conclude the session now.
Ma'am,
Yes.
there is one issue while
Yes.
filing the dissolution, you have to file the closure of the liquidation account with the application.
Yes, sir.
And then in that case, if you close the account, what about the avoidance application, legal cost and the other proceedings which are continuing?
So for
How
that
to meet
only,
that?
sir, practically what happens is, while liquidators file this dissolution application, they do not close the account at the very initial stage of filing the dissolution application itself. Rather, what they prefer is they file the application, because when you are filing the application, on the very next day, the matter is not getting listed. Matters
No,
get
that
listed
is
on
true, but
adjudicating authority on several locations. Sir, I'm just answering your query only. So what liquidators are following practically to come out with this difficulty, when the matter is listed for final hearing at the end stage, they take directions from the bench to close the liquidation account and file a supplementary affidavit at that time, and not at the very initiation of filing the dissolution application itself. So by way of a supplementary affidavit, when the matter is coming to the conclusion, at that time only they file the affidavit with the adjudicating authority, giving the details that now the account has been closed. Or otherwise, the other options which also the liquidators are exploring is that they keep out certain amounts, they keep aside certain amount for meeting these expenses till the dissolution of the corporate debtor. And once the dissolution process is complete, then whatsoever amount is remained, so in way of the priority, they are distributing that amount. So of course, with the consultation of SEC committee, they are keeping aside some amount to meet the expenses till dissolution of the corporate debt. So
in
these are
the name of whom that amount can be kept aside?
In the liquidation, in the name of the liquidator only, sir. But of course, with the discussion with the SEC, the SEC permits for the same. So once the process is complete, they are required to inform the SEC as to how that amount is being used by the liquidator, and if at all there is any surplus money remaining, that amount will go to the stakeholders in terms of the priority of 53.
And in the other question which I had raised, that there are recovery suits which were filed by the CD prior to the CIRP or the liquidation. But if those suits are not to be continued, because that is a maximization of the value of the CD. These are recovery suit filed by the CD. Of course, there is no headway. The dates are there. The cases are going on. But at a later date, if some debt is decreed and some recovery is there, how that money will be distributed and dealt with?
So first thing is that if at all there is any such kind of assets which are litigated assets, and if you are intending to sell the corporate debt as going concern, so that
No,
you have
it is based on the
other modes.
Other modes.
Other modes. So if at all
assets
there
are sold on piecemeal basis, and these recovery suits are going on, which have been filed, but the only dates are there. And suppose tomorrow some decree is there, some recovery is there, and in the meantime we have filed the dissolution. How to where that money will go?
These kind of assets are actually treated as not readily realizable assets, sir. So the liquidator may treat them as a not readily realizable asset, may keep some of those assets together, and may explore the value for those assets as well. So say suppose there are some litigated assets, some other assets which are currently not fetching any value, or in the near future it are not seen that. Say suppose
these are all contingent asset, you can say.
Yes, so these contingent asset will be in the nature of not readily realizable asset. So what the liquidator can do is the liquidator can combine these assets and can try to explore with the consultation with the SEC, try to explore the interest, if at all any acquirer have interest for these assets as well. Now say suppose the expected realization from these kind of NRRA is say suppose around 5 crore or 50 crore whatsoever, and the acquirer is fetching a certain value which is otherwise acceptable to the SEC, then liquidator may proceed ahead with selling of those assets in the manner as agreed by SEC. So that is why the very reason of this NRRA insertions was there in the liquidation regulation, that these kind of contingent assets can be explored by the liquidator by way of selling these as an NRRA.
No, but there is a provision of distribution of the NRRA.
Yeah, so whatsoever you realize, so you have combined the assets. Say suppose there are 2, 3, some kind of suits, some kind of recovery proceedings which are there. You have combined this proceeding, and now you are exploring if at all there is any acquirer who are also interested in purchasing these assets. If at all there is any acquirer who are interested or who have expressed their interest in acquiring these kinds of assets as well, in that case, that particular acquirer will fetch a value to you. So
Of
that
course,
value will be
that
realized.
is a
That
very
value.
optimum,
Yes, so what value you will receive, that value you will distribute as per 53, and the acquirer will see as to whether to continue with those proceedings or to give up with the proceeding, not to continue with the proceeding, because now that proceedings are acquired by the acquirer. So it is the acquirer to see whether to continue with the proceedings or not to continue with the proceeding. Now liquidator has no role to play per se, where it is already acquired by somebody.
One more query from my side.
Yes, sir.
In few cases, promoters are either not cooperating or not providing any details. In case of income tax login are not provided, then as a liquidator or as a RP, the IP has to deduct TDS and deposit with the income tax department, and correspondingly amount has to be deposited with the income tax department, and Form 16A has to be issued in favor of the person from whom that amount was deducted. But now the system has changed from the income tax. Now only payment can be made only by logging into the income tax department website. And once you once you pay from the income tax website after logging in, then only the challan will be generated. And at times, if I submit all these things to my bank, and I say that you have to take the deposit in the name of the income tax, they can accept the income tax by way of TDS, but the challan is not generated from the bank website also. They are also helpless. So if I'm not having the income tax login, then I can at best deposit the amount of the TDS, but I cannot generate the challan. And since the challan cannot be generated, then I cannot file the TDS return also. So there is no use of depositing the TDS to the income tax department. Then what to do? Because if I don't deduct the TDS, then I am at fault. And if I deduct the TDS, but I am not getting the credit for the TDS, then I'm losing the amount also.
So for this issue, section 19 is there, which says that the management and the promoters, they are required to provide necessary cooperation to the liquidator and to the insolvency professional during this continuation of process. So say suppose you have been appointed as a liquidator and the promoters are not cooperating, they're not providing the necessary user ID password. Before you, the resolution professional was there. And certainly the resolution professional was also filing the income tax returns, etc., whatsoever is required to file. If at all resolution professional has those, so of course, resolution professional will provide you the necessary details. If resolution professional also could not have filed these returns, could not have got the details from the promoters, then resolution professional also has this option to explore section 19, file an application with the adjudicating authority that the promoters or the management is not cooperating with providing the necessary information that are required for continuation of the process, like for filing the necessary returns, etc. And necessary directions can be given by adjudicating authority to provide the required details to the liquidator. So ideally, there should not be any hindrance on this particular part, because the law is very strict when it comes to section 19 of providing cooperation to the.
In my case, I can say I have two cases. In fact, I can say both ran from CIRP to liquidation. But in both of my cases, I am not having any user ID password from the income tax department. In one of the case, the promoters are behind bar. They are behind the jail, and so many UOWED cases are going on. So they are not approachable. So they are not providing anything. So the registered office of the company is also under lock and key. I cannot use that one also. So there is no option that I can have the income tax login password. I have approached to the income tax website, income tax department. I have written so many mails to the income tax department as well as on the customer care, but they are saying that either you do it with the DSC with the forget password, or you can go through the some things are there, but those things are not available with me. So they are also helpless, so they are not providing. In another case, what happened? The promoter is not providing anything, and even after 19th order, they did not provide anything. The NCLT passed the order that RP can do take any action as required, but he's not, since he is not providing nothing. So I can go ahead with the section 70 for punishment, but he's not providing. So both of my cases are stuck with no income tax login.
In that case, the concern are basically related to income tax returns only. So assessing officer may help. So you may have the necessary orders from the adjudicating authority produced before the assessing officer and asking the assessing officer to help you in this particular part, because it's a case specific issue that the
No, it's not only, these are only my cases, but I think there are so many other cases also. In case of attachment by the ED or CBI, the promoters are not traceable. And
because in generally, sir, these returns are not filed by the promoters. These are filed by the management, the board of directors or the company secretary or the necessary, the respective professional as may be employed by the corporate debtor for filing the returns, etc. So if at all there were some professionals, so help can be provided by those professionals. In fact, now law also requires all the creditors and all the professionals, etc., to provide necessary cooperation with to the insolvency professional. So of course, if at all there is something like that, then necessary cooperation should be provided, because of course the promoters would have taken help of the professionals to file the income tax returns during their survival, during their continuation with the corporate debtor. So if the professionals, if you can help, take help of the respective professionals, that those professionals can help. Otherwise, assessing officer is the best resort. So assessing officer can provide the necessary guidance as to how to retrieve the password and how to continue with the same.
Ma'am, I have one question.
Yes.
And there is a company under liquidation, and company has taken a term loan for construction of its building, and the land on which building had constructed belongs to one of the directors of the company, and that director has mortgaged that land with the bank, and building has been constructed with the funds borrowed from the bank, and the remaining some funds are also introduced in the construction of the building by the company. Now as the company is under liquidation, and bank is saying that land belongs to the promoters, land does not belong to the corporate debtor, and therefore the building constructed on that land, as building cannot be constructed without land, it will also not form the part of the liquidation estate. But as building has been constructed with the funds of the corporate debtor which has been raised from the bank. So what is your view that the building portion of the building which will be realized later on at the time of the sale will become part of the liquidation estate, or will be the part of the director as a personal guarantor?
Sir, ideally, what should be a part of liquidation estate is provided in law itself. That's something which is in my name, or something which otherwise is being used by others but is in my name. Maybe I'm not using it, but is currently used by other, but that particular property is in my name. That is forming part of liquidation estate. Something which is not in my name, how can I claim that as my property? So if there is any certainty or any kind of confusion in that regard, the necessary clarification may be sought from the adjudicating authority to guide on this particular part. But if the property is not in the name of the company, in that case, certainly in my view, that should not form part of the liquidation estates.
Even though the building has been constructed with the funds of the corporate debtor.
So these are like avoidance transaction, like fund of the company is being used by the corporate debtor for personal vendetta, etc. But the particular building is not in the name of the corporate debtor itself. So
please carry on.
There, sir, corporate debtor cannot claim that property that property was formed using my fund. Even if the property was used by using the fund of the corporate debtor, that you can drag those transactions under the purview of avoidance transaction application, but you cannot treat that as a part of corporate debtor's property itself until unless decided by the adjudicating authority.
But basically, books of accounts also, in the audited balance sheet, there is a value of the building assigned in the books of the corporate debtor, and that is the same building which has been constructed by the corporate
whether that is showing under the head of assets of the company itself, under the fixed assets part of the company itself, whether at all that is showing as a property of the company.
Yes, it is in the.
If it is showing as a property, so sir, there are two things. One, you are saying that this is not shown as a property of the company and that were in the name of the promoter. If the
No, madam,
properties
land,
are
actually land is in the name of the land was in the name of the promoters. And when company approached the bank for the construction of the building, bank asked for the guarantee and promoters put that land, give their land mortgage with the bank, and bank then gave funds for the construction of the building to the company, and on that land only the building for the running the business of the company was constructed, and funds
so
of
the building ultimately in whose name, sir? The building must have been registered in someone's name, no? Where is the what the documents of the building says? What is there in the building documents?
वैसे तो मैडम एक्चुअली सिर्फ लैंड का ही डॉक्यूमेंट होगा ना, बिल्डिंग का तो कोई डॉक्यूमेंट होगा नहीं। बिल्डिंग तो
सर जब बिकेगा तब सोचिए, अगर बिल्डिंग बिक रहा है तो वहां बिल्डिंग में अगर किसी का नाम ही नहीं है, हम सिर्फ लैंड का ही नाम रखे और लैंड जिसके नाम पे है वही है, तब तो लैंड जिसके नाम पे था बिल्डिंग हार्डली उसी का हुआ। अगर हम बिल्डिंग ऐसा रखते हैं, बहुत बार ऐसा भी होता है ना कि हम लीज पे लेते हैं लैंड को और उसमें हम अपनी बिल्डिंग खड़ा करते हैं, तो लीज पे लैंड था, वो जिसका लीज था उसका था, लेकिन बिल्डिंग तो मेरी है क्योंकि बिल्डिंग जो बना हुआ है वो मेरे नाम पे है। तो ये सिचुएशंस जो है वो अलग होते हैं। अगर ऐसा है कि वो बिल्डिंग मेरे नाम पे है, मेरे बुक्स में दिखा रहा है कि मेरे नाम पे है वो बिल्डिंग, देन ऑफ कोर्स आई कैन claim that particular building in my asset as one of the assets of liquidation estate. But if at all that is not in my name, then how can I treat that particular asset as a part of
Madam, can I?
Yes, sir. Yes,
Madam, I think it's not complete as of now. There are few cases, and this is the mingling of the assets. It is called, the term is the mingling of the assets. The assets are so many and related to only one loan. So it is not unusual. It is a usual practice that the promoters are going to the bank for taking the loan, and they are providing several assets, which may be in the name of the city, which may be in the name of the corporate guarantor, which may be in the name of the joint of the promoter also. But the only thing is, they also mortgage the property. It's not there that mortgage is not there. So the property is mortgaged, and the personal guarantee or the corporate guarantee is also given simultaneously. So it's not only the building is there, land is not there. Land is also there, but in the name of the promoter. And that promoter has also given personal guarantee to that extent. There are a few cases, like in one case of Ayan Malik versus Pratim Payar, liquidator. The similar case was there, and Pratim Payal approached to the NCLT that so and so the thing is there, and if I don't sell both the assets simultaneously, then I won't be getting maximization of profit, maximization of the value of the CD. Then NCLT provided that land should be sold out under the SIRP simultaneously with the process of selling of the liquidation assets through the auction, and in that way, the same person can acquire from the SIRP as well as from the liquidation under auction. So this is the case of Pratim Bayan. Now one more case is there in the name of PNB versus Vindhya Vasini Industries Limited. Under this also, the similar position was there, and the author discussed that the decision to liquidate the property belongs to Srimati Saroj Singhania, who is the proprietor, who is the promoter, and who guaranteed the loan. It explains that since her property was mortgaged to the bank under the same loan agreement, liquidating it would help realize the debt amount and prevent a significant haircut for the bank. The decision to liquidate the guarantor's property is justified under Section 60 subsection 2 of the Insolvency Code, which allows for the filing of application relating to the insolvency or bankruptcy of personal guarantor of a corporate. So it started with the personal guarantor liquidation and insolvency, and both of them sold out together. So these are the few judgments wherein joint property in the name of the CD as well as in the name of any other person, may it be a corporate guarantor, may it be a personal guarantor, both can be sold together.
Sir,
so again, sir, you are referring to joint property. Here he is saying that
not the joint is a property in which is jointly held.
Jointly held again. So
like say land in the name of a promoter, factory in the name of the company. This
but he is saying Sir, the concern here, the question here is that the building is not in name of the company. So nothing is in the name of the company.
Madam,
building
building
is-
is in the books of the company.
In the books of the company, building has
So
no name.
exactly, if you are saying that it is in the books of the company, then certainly you have a right. If you are
Of
saying that there is nothing in the name of the
If-
company, nothing in the books of the
otherwise,
company, then you cannot claim it.
Agar if we have taken someone some government's organization land on lease and on that we have constructed our building, then definitely building comes in our name. But in
Yes.
the case, in this particular case, when the land belongs to the director or one of the promoters and the building has been constructed by the company on that land, in that case, building can't never be registered in the name of the company. The only way is to that building comes in the books of the company, and we have the invoices which have been which proves the expenditure.
You write down the case law with PNB versus Vindhyavasini Industries Limited. Huh?
Sir, PNB versus
Vindhyavasini Industries Limited.
Vindhyavasini Industries.
Vindhyavasini Industries Limited. Another case is Ayan Malik. Another case is Ayan Malik versus Pratim Payal, liquidator.
Pradeep.
Ayan Malik, AYAN Malik versus Pratim Payal. PRATIM Pratim Payal, liquidator.
सर ये किस एनसीएलटी के हैं दोनों केसेस?
एनसीएलटी न्यू दिल्ली के हैं.
एनसीएलटी न्यू दिल्ली. ओके, थैंक यू वेरी मच सर. थैंक यू वेरी मच. थैंक यू मैडम. थैंक यू वेरी मच. मैडम आप म्यूट हो गए हैं.
सर ये ओनरशिप ऑफ प्रॉपर्टी को लेकर के जब कंसर्न आता है तो भी लिक्विडेशन स्टेट का अगर आप डेफिनेशन देखेंगे सेक्शन 36 में तो वहां पे होता है कि एसेट्स व्हिच आर सब्जेक्ट टू डिटर्मिनेशन ऑफ ओनरशिप बाय कोर्ट और अथॉरिटी दीज आर आल्सो अ पार्ट ऑफ लिक्विडेशन स्टेट. So even if the concern is that the ownership is in question, then also you can claim that asset as an asset of that is forming part of liquidation estate once it is decided by the court or the respective authorities. तो अगर ऐसा भी कंसर्न है कि आप यू आर नॉट श्योर, क्योंकि देखिए जो भी खरीदेगा whosoever will purchase the person has to have the certain documents. आप ऐसे ही तो कोई प्रॉपर्टी नहीं खरीदोगे हवा में. If you are also purchasing an asset, you will also need a proper documentation of those assets. So if you say that I don't have any document, the building is in the name of that person and those persons are no more there, they are in jail or they are in whatsoever, so I'll not be able to provide those documents. The acquirer will not get that surety of buying that particular asset. Whosoever buys the asset, the person always wants the particular documentation of the asset. So to ensure that whatsoever you are transferring, whatsoever selling, you have that the potentiality to make the particular documents to give the transfer the ownership as well. I will recommend personally that to have the clarification from the adjudicating authority in this regard that these are the assets and whether these assets I should claim these assets as a part of liquidation estate only. So as to have a clarity, ताकि आप जो भी acquirer को भी देंगे वो acquirer भी ownership के साथ उस asset को acquire कर पाए.
Ma'am, let me clarify you one more thing. I think I do not agree with your version here. This is very clear that the ownership of the property cannot be decided by the NCLT or NCLT because these are summary proceedings, and summary proceedings are beyond the NCLT jurisdiction. You can refer the case of Incap Intercity Limited versus NCLT Kolkata. You can refer the case of Jupiter Spun Pipe versus NCLT Kolkata. And both the cases related to mine Jupiter under Jupiter, I was the RP therein, and it was decided by the NCLT that since it is beyond my jurisdiction, I cannot decide. And we also argued that these are beyond your jurisdiction, so you cannot decide on that one. So the NCLT given order that since I am not in a position to decide that, then it should be relooked.
Sir, but there are competent court to decide on this properties part. Yes, so if you see the provision of section 36, sir, 36, which also includes that assets subject to determination of ownership by court or authority. So their respective courts may be approached by the liquidator to have the authority and accordingly so that the particular ownership is also getting transferred to the acquirer. Because as I said, कि आप बोल रहे हैं कि आपके पास कहीं आप बुक्स में दिखा रहे हैं आपके पास कोई पेपर नहीं है, कुछ नहीं है. कल दिन जब आप बेचेंगे जिसको भी आप सेल करेंगे उसको आप ओनरशिप कैसे ट्रांसफर करेंगे, वो कैसे उस एसेट को अक्वायर करेगा अपने नाम पे, वो कैसे ट्रांसफर करेगा उस एसेट को अपने नाम पे जब आपके पास कोई पेपर ही नहीं होगा.
If there is no dispute, then there is no harm. If there is a
there is
dispute,
no that is so, of course, if there is no
if
dispute,
there is
there
a
is no.
dispute,
But
if there is a dispute, then the NCLT will not say anything. The
not
NCLT
NCLT, but the competent authority, maybe court or the respective authorities who have the determination, who have the right to determination.
other competent authority are civil court and the high court,
It is civil
and
court.
they usually take 5 to 7 years for having a decision on who is the owner, not less than 5 years. So it's not a possibility for any liquidator to continue contest with the civil court or the high court for next 5 years, and those liquidation will not stay here for the next 5 years. So this is very clear because I am facing this issue in my own case, and NCLT has simply said that I am not in a position to provide you any detailed position. If it is acceptable, means it is information is there in the record and in the books, then I can decide. And if there are too many persons are there who are claiming to be owner of that one, and other things are there, so we are not in a position to provide information, and we cannot wait that you approach to the competent court and you come out after, because they will take 5 years. Then how
you have sold the assets, sir, ultimately?
So
Madam,
now?
what I think what Mr. Singhania is saying is this that case is out of this out of this planet, it looks, because there are 5-6 claimants. I know that case. There are 5-6 claimants in that. BSIDC sold it to first it was taken over by the liquidator ROC. Then it was sold to BSIDC. Then it went to MSCPL. And then there were some private businessmen who were claiming the ownership. Bank was the claimant.
So
there was another party. In normal situations, in normal cases, how can bank have such protection?
No, I'm not asking for any particular case. I am giving you just the example that things are there, that if the dispute is there, the NCLT will not be in a position to provide any clarity on that one.
No.
Mr.
And the
Kumar,
bank, how can bank claim claim protection on such an assets which they are willingly acquiring? Just a minute, let me complete, Mr. Singhania, please. When they are the bank is willingly acquiring such lands which they know that on which the flats will be constructed, and those flats will be allotted to the buyers, the particular buyers, and they will have the claim on it, and still the bank is still accepting those lands as security. So you cannot, for your own.
One more. May I intervene?
Yeah.
Mr. Ajay, I think we are having a technical session, or we are having a workshop. It is better not to decide on the case specific, because the matter is before the educating authority. So it is better that we should not discuss it over here. If any common issues are there, then it can be discussed. But I am not interested in talking about one particular case in which I am RP, and I'm not going to provide any further detail.
Exactly. In general, whatever we face, exactly. That is.
So basically, sir, the thing is that only that liquidation is, of course, a case specific thing. In every cases, the liquidators are exploring new things, and accordingly, they are suggesting the IBBI to make necessary changes so that the liquidation process can be concluded smoothly. So these things, the law is still exploring, amendments are still coming in the liquidation process as and when required, to give necessary guidance to the liquidators to how to proceed with the things. As I said, in liquidation, while during CIRP, there are several laws which are dealing with the things that the liquidator, that the RP or IRP is required to deal with during CIRP process. But in liquidation, there are still several things, several subjects in which clarity is needed. So clarity is not there on several subjects. And therefore, the liquidator are exploring, or liquidator are doing their best based on the references that they are getting from other cases, or from the references that they are getting from the judgments, erstwhile judgments, etc., of similar line. So the law requires clarity on these aspects. Is there any particular other questions from any of the participants?
Thanks, madam. Thank you.
Anjali ji, if there are no questions from the participants, we can conclude the session today.
Yes, ma'am, we can conclude.
Thank you so much, everyone. Thank you for participating and for asking questions and making the session interactive. Thank you so much. Thank you, ICSI.
Thank you to all.
Thank
Bye.
you, ma'am. Thank you very much.
Thank you.
I would like to extend a heartfelt gratitude to our ma'am, Miss PCS Barsha Dixit, ma'am. Thank you so much, ma'am.
Mr. Ajay, may I have your contact number?
Sir, I guess she left.
Hello, Mr. Singhania.
Yeah, may I have your contact number? I want to.
Yeah, 94 318 00 678.
Thank you.
Mr. Singhania, can I have your contact number?
Yeah, it's 94 330 68 790.
So nice of you, sir. Sir, can I call you back later? So nice of you, sir. Thank you. Thank you.
May I end the session?
Please.
Okay.